Mr. Frank?
Oh.
All right, fair warning, everyone, we're live streaming now. So we'll be on YouTube. Image capture view. These are the cameras for the live stream and for Zoom, and they should be directing themselves to whoever's speaking. So if you're within the circle here, you're speaking, you're most likely going to be on them. You got live. So let's just hit a couple preliminary things before we get started. Everyone's parked, thankfully. Sign says the parking garage closes at 6, but I think I don't expect to be here later than that. Because we have multiple days, but in case we're in the middle of something, we'll keep going. Parking garage the gates will close after hours. You just have to drive up to it and the gate will open. I've been there before. You're like, why am I locked in? We have those spillover rooms. Doesn't look like we're gonna need it. We have people here, but in case you want to meet during a break, it's S107, which is around the hearing room to the other side by the employee entrance, and S159, which is you go down and then to the left, it's the main hallway on the right, that main hallway. So I think parties have worked out who's sitting where. That's great. Thanks for doing that. So we have the Zoom cameras, and they're going to be recording and video and audio all the time unless I turn off the Zoom. But if you want to speak so people can hear you in the room, people around the table, you've got your microphone. The green light means the mic is on. And if there's a little button that says push that, the light will turn off. Push it goes on. Yeah. The other cameras and mics will be on all the time, so probably doesn't make a lot of sense to be turning your in-room mic on and off. It's not really going to stop people from hearing you. But everyone in the room will be able to hear better if your mic is on. This mic is on. Otherwise, I think we're all set. So we have a representative of each party who has a witness at the table. Looks like we're good with that. And we'll get started. So, boy, it's weird, but it's good. So let's get on the record. Okay, welcome everyone. This is docket 2820. This is docket 9827 CE100. Badger Hollow Wind Farms application for a wind generation facility. My name is Michael Newmark, the administrative law judge for the PSC. We're here at the PSC hearing room. All awaited our meeting today. I appreciate everyone coming out. We're also conducting this hearing over Zoom. And let's begin by getting our appearances on the record. We'll start going through our service list with the applicant.
Good morning, Your Honor. Jessica Polakowski appearing on behalf of applicant Badger Hollow Wind Farm LLC.
Clean, Wisconsin.
Good morning. Katie Nicola on behalf of Clean, Wisconsin.
Party, well, you guys just gonna use your full names now. Linda Grice.
Good morning, Linda Grice.
Perfect. Who's here for the Jenkins?
Progressive Law Group, Attorney Frank Jablonski for the Jenkins.
Metallica?
Gina Metallic.
Mary Owen, I know you're on Zoom. Just want to chime in. Okay, well, I'll note that you are on Zoom here connected. Public Service Commission.
Evan White's on behalf of the Public Service Commission.
Larry Regan.
Larry Reagan, right here.
Renew Wisconsin.
Corey Walsbeck, law firm Michael Friedrich on behalf of Renew Wisconsin.
George Schwartzman.
George Schwartzman here.
Perfect. Trustees of 435 County Highway E.
Good morning, Amy Jo Hunt for the trustee, 435 County Highway E.
Wisconsin Policy Monitor LLC.
Eric Olson, appearing for Wisconsin Policy Monitor also.
Okay. So let's go off the record for a So I think these cameras pick up voices, so if you want to speak up a little bit more next time, yeah, your mic.
I think I have it on.
Okay,
Eric Olson for Wisconsin Policy Monitor LLC. Yeah,
okay, yeah, well, not showing your face, but next time maybe we'll just try to speak up a little bit. Thanks. All right, so we've got, let's back on the record. So this is our party hearing session today. On location, we'll be planning at least tomorrow and tomorrow in the room, possibly Thursday will be Zoom only. Because of the conflict with the space. But next week, June 24th, we'll be in the public hearing session, the community building in the village of Linden. We'll take public comments at that time. We're also accepting public comments online. Those are due Thursday, June 26th. They can be filed, like I said, online, and we'll also accept those written comments through the mail. They just need to be at the commission no later than June 26th. Admitted to the record. We are live streaming. There's a way to view this hearing on our live stream, and that information is in our notice of hearing. And just off the record, if you're in the spillover room, we don't have a connection to the live stream up and running, but I would just suggest you use the link here to watch the hearing on YouTube on your phone or whatever device you might have available. All right, I'll leave to that. So next up, let's handle some of our preliminary matters. Okay, I don't have the list in front of me, but I think I can do this from memory. Everyone can check me on this, but let's get on the record just to discuss some of the questions in the case before we take our first witness. We have a number of motions that are pending, and those are the motions that are pending and allowed. We will review before we take our first witness. Hopefully we'll have the record set straight before we take cross-examination. It's a number of motions pending, and I wanted to sort of deal with them sort of as a group, because I think a ruling on, well, actually, what I was going to do is go through, because there's so much changes that have been coming through with surrebuttal, and new exhibits. They brought to light to me some questions about some of the past filings as well. I did come up with some more instructions about refiling, even going back to direct, that I want to review. And I think when we go through them all, the fallout of that will be decisions on the motions. And so rather than going through all the motions and hearing all the arguments, I think I know where I'm headed on these things, and I can basically give you we're going to mediate the what's being offered for the record in order to handle all the complaints about these filings. This might be the most, I'm sorry, sir, off the record. Is it too loud in there? Is that the problem?
Yeah.
Okay, can somebody watch that door? Because I don't want people turning away. Can you just make sure they're unlocked on the other side? The one door is unlocked. Yeah, we unlock the other one. acoustics in that hallway are terrible, so. I used to say we cannot shut the door ever, but just can't work with it. Like that. Okay. So. So let's back on the record. So basically, we're gonna go through the offered evidence list. If there's issues I haven't addressed in your motions, we can raise them, but I'm gonna go through each party and discuss what I plan to receive into the record, which is gonna be slightly different than what you may have seen before, so. I'm gonna actually skip the applicant. I think there's one question I had for them. But I think it's going to relate to some later items too. Clean Wisconsin is easy. Bryce, okay, so. Bryce rebuttal. And. The Metallica rebuttal. Sorry, off the record. Anyone recognize Wes Venderdorfer? Okay. Oh, yes, there. Wes, I see you connected to the PSC hearing on Badger Hollow.
Yes, thank you.
Yes, so you're not connected with any of the parties, are you?
No,
Okay, so I'm gonna ask you to watch the hearing on our YouTube live stream instead of connecting through Zoom.
will do. Thank you.
All right, thank you. Oh, so, well, first we're gonna look at the, so there's motions about those, two filings. I wanted to look at the, Bryce filing. And the. Let's start with Metallica is correct. That might be the most useful one. So I saw some on Metallica's surrebuttal references to two emails that were filed as exhibits, and I don't think that those are, we can rely on those emails as evidence. So concept here is I'm looking for what has probative value, and I'm looking for what we can rely on for the truth of the matter. And when it comes to emails from people that, we're not talking about published articles, we're not talking about something that can be checked or referred to by others. The emails I don't think are acceptable for the record. So when it comes to those emails and the conversations that in the testimony that was based, testimony is also based on some conversations with these people that these emails involve. We need to strike those from the record. So I do have some directions on that. Yeah, so on Metallica's direct, page 9, lines 6 through 19, we need to strike those. They're based on emails that we, and YouTube videos that we can't verify independently. The, page 13, lines 16 through 19, there's, the email exhibit and testimony related to that, so that's stricken, as well as, Metallica 11, exhibit 11. Page 9. Page 10, footnote 12. Just need to change the citation to that. I'm gonna have to give you more of these instructions in writing, but basically taking out the emails and the testimony related to that, I think cleans up Metallica's testimony, and I can accept it for the record in that, for that reason. I guess this isn't as organized as I thought I had before. Spending many nights and weekends on this case, but I've really lost the point. Okay, so Bryce. Oh. So Bryce rebuttal, it's just basically citing an EPA document, and I think it's not quite rebuttal, because it's saying applicant didn't respond to my direct, didn't in the applicant's direct, it did not address the issues I wanted the applicant to. Here's some additional information. It's not quite rebuttal, and I don't really know if it's very probative, but I think on balance, I'm gonna let that testimony in, because of the concept of giving, parties the, opportunity to present their position on the case. Commission can weigh it to the extent it's, it wants, and give it the, give it the weight it wants, and, weigh its credibility, simply and, exhibit from, or a document from EPA. So when we have the Grice rebuttal in place, then basically raising issues about PFAS, I can accept therefore the Badger Hollow Sur rebuttal from Kurtz, which does mentions that testimony and adds evidence in response. I don't find it very useful, but I think it's in the record one way or another at this point.
Your Honor, just to be clear, that, are you saying that the Kurz rebuttal is in?
Yes.
Thank you.
Yes, and I think just on balance, I'm gonna let testimony in. And then the commission's gonna review it, so I'm not gonna be striking in terms of the filing that files evidence that's already been offered, so. And in that sense, I'm also wanted to reconsider the Wisconsin Policy Monitor testimony, the direct of Brown. There's some modifications I'd like to make, but I think because it wasn't responded to by the applicant, I can let it in under this theory that commission will weigh its credibility and will give it the weight it deserves. Let me just get to that while we're here. So there were some particulars for Brown that I was not going to update. So on page 3, lines 20 through 21. Striking the, and an example can be viewed, and to the end of that YouTube video link. Brown 5, page 5, lines 11 through 18. Each strike starts with a copy of the article and ends in Brown-8. At Brown 6, line 2 through 6, strike the sentence starting with the article and ends with Brown 10. And page 6 again. Oh, that's the whole, so the whole portion striking lines 1 through 13 on Brown 6. Because it's referring to an article that has no author. So I'm not gonna allow that, relying on that. But otherwise, I think Brown, and then there's the striking of the actual exhibit, so the 7 was due to, 7 is the same as punch 6, so it's just beat the thing. Brown 10 is no author, and Brown 11 is a Bryce 7 seems to be also duplicate of Bryce 7. So there we go. I do want to mention, so for Reagan and Schwartzman, I'm still going to reject those filings, the rebuttal filings, because they're duplicitous of direct. So it's just not adding anything to their that the commission can use to decide the issues in the case. Basically reoffering the evidence that was presented on direct. And just so you know, in terms of our process, you don't need to reassert what you said before. You just, whatever someone says something counter to you, and you don't respond, you're not recanting anything, you're not agreeing or acquiescing to that. What you said lays on the record and is true for you. You don't need to restate it to be able to carry it through the rest of the case. Okay, now I'm on a roll. So I had a question, I think it was Metallica 32. And I wasn't sure. Let's try this one. I know this was filed. Oh. It's like no. This was a pamphlet related to karst geography, is that correct? And this is something that you're presenting here today, or is it?
Adding to everything that
Yeah, so I thought, okay, so that's not something we're dealing with the filings, home filings. Okay, I wanted to mention Metallica 8. I've created a revised version of that. So originally the witness the party had offered the originally the party offered the order on reconsideration from the Ohio Siting Board related to a wind farm in Ohio. The revised exhibit that I created contains both the original order and the order on reconsideration. I just want to people know that will be coming, and I can probably file that. It doesn't look like this document's working. terms of Metallica surrebuttal. I do have a number, so I would, again, under the theory, the commission can look at it and take it for what it's worth. I did have a few things that needed to be stricken. And they're related to these email exhibits that were part of, that were also referred to in direct, so. So the exhibits were both, the exhibits were 20, 29, and 31 ballot exhibits. And then, in terms of striking those portions of surrebuttal, it would be, let's have page 127. Yes. It makes sense that. So Metallica, page 1, line 27, just a reference to the exhibit. Page 2, line 2 is a reference to the stricken exhibit. And then page 3, lines 30 through 32 deal with this quote from the stricken exhibit. Metallica, page 4, lines 1 and 2, page 4, 20 through 30, page 5, 1 through 2. Should be stricken as they relate to those.
Your Honor, may I say something?
Well, I'm allowing your testimony, but I can't accept the
Okay.
references to people that we can't see, can't hear, and just based on emails. So if you had, I can note your argument for the record, but I'm pretty much gonna stick with my decision, so.
Only
Um,
because it's a follow-up to exhibit 21, where Dr. Day's reference with the chapter that he wrote on Wisconsin AIDS and cars. So
I'm sorry,
there's a
Wisconsin.
connection.
I'm sorry, that he wrote in Wisconsin.
In Wisconsin, Caves and Karst is the title of his chapter.
And it's,
Exhibit GM Metallica 21.
right, which I think is also. So. So Caves and Karst of the Upper Midwest, that's,
That's the whole book. And then the chapter 6, which starts right there.
so that we are accepting on the record as published articles, so that can be used in evidence. Anything else in terms of what you have heard from this person or, emails that we can't verify, I'm not. Okay, so now we have, so let's get back to Bryce. We do have an issue with her, request for leave to file supplemental direct, I believe. Is that correct? Okay, and then 2 exhibits, right, 13 and 14. So. So I think there's an issue I have with filing additional direct today. The. These articles do not appear to be, were available before today. Is that right?
Correct.
Yes, yeah. And just bringing it in now. I think with all the documents we have and that I am letting in. Bringing this in now does not give, I mean, at least I would hope that the applicant would have an opportunity to review and vet these documents in a substantive way. Bringing them in now does not allow that opportunity, and I need to balance that out between letting things in and at least giving the other parties and staff an opportunity to review before we get to this day. So I understand time constraints and, you know, the fact that you're not represented by an attorney, but I think that it's outweighed by just the element of surprise putting these in now. So I'm gonna have to reject that offer for that extra direct testimony on the day of the hearing. So that would be 13 and 14. Well, I have a number, so if we move on, so with Bryce, are there any issues? Oh, so let's move on to the Jenkins testimony. Check if there's any, I think there were a few changes. We went through the list and we saw some duplicates. And where you're referring to, where someone's parties are filing the same document. And then citing to it, so I do have a number of those. So we do have the Brown exhibits are now in, so that, although this was all beforehand, so I think there's direct Jenkins. Oh, is it Jenkins 1? You want to refer to Brown 11? That's something I'd said before. Jenkins 1 is the duplicate of Brown 11.
Your Honor, if I could just raise a question about Brown 11, I think Brown 11 is the appendix, I have it correct.
The other way
Appendix
around.
E of the Wind Siting Council report, which I think may have been Bryce had put the complete document in Bryce 7. So I don't know if you want to address that.
Okay. Yeah, I think this is in so many different ways. So, oh, this is just the minority part. Okay, yeah. So whoever had the full document with the minority report attached, that's the one you want to cite to. Is that Bryce 7
I
then?
believe that's Bryce 7.
Okay, yeah, so whenever you're referring to the wind sighting, report of, 2004, May 2024. Did I say 2004? Whenever you're referring to the wind sighting report of May 2024, use Grice 7 instead of whatever else you've offered. And that includes when you're citing to the minority. But nothing else for Surabuttal. Chicken, so hang on. Looks like on Punch's rebuttal. Punch 36 is the same as, is it Helen Bogan? Helen Bogan 6. So you want to change your reference from Punch 36 to Helen Bogan 6. I think we have a similar issue with the Punch rebuttal that we have with Bryce. The new exhibits that were filed for the hearing today, and I'm not sure exactly when it comes to Punch's the offer exhibits 43, 44, and 45. They don't seem to be related to the surrebuttal, or they seem to be more of rebuttal exhibits. So why they're coming in now, not quite sure.
Your Honor, if I could speak to that. Okay, so 43 is identified in Punch's surrebuttal. But I didn't.
You didn't put it in.
Yeah, I didn't file. And then the 43,
Right.
44, and 45, from our perspective, are associated and with the surrebuttal, which we filed. We thought that was the civil thing to do, not the sandbagging thing to do, to give people the opportunity as opposed to put them on the stand. 46 doesn't exist. 47 is the Invenergy letter that you had given us the opportunity and I had neglected to file. I'm not sure that needs to be filed as an exhibit. It's a letter that was filed by Invenergy. It's on the PSC website in another proceeding. It's PSC 445.
Yeah, no, wait, you don't have to give us the numbers.
Okay, so, and Dr. Punch referenced it as in the context of what did
Yeah,
you?
let's just
review?
take one thing at a time. So the 43, I'm with you there. So 43. 43 and 47 kind of relate in the same, in a way. So 40, I read the Punch Direct. It referenced an Invenergy letter.
Yes,
And the first thing I asked myself was, where is this letter? So on my direction, I asked you to file that for
yes,
the record, and it's going in the record, I believe. It needs to be filed in the record because you can't cite to a non-record document. So if it's on Earth, anything on Earth is not in the record. Only things offered as exhibits are in the record. So you can't cite using a PSC reference number, that won't work. You can't bring documents in like that, and you can't bring a document in unless you actually offer it. So I think it's valuable if you're gonna cite to it. We want to know what it says. It's the first thing that came to my mind. So it's gonna go on the record as 47, but that was by my invitation that you were able to add that in and basically cure your direct, because the direct really makes no sense unless you see the document that you're talking about. 43, however, exhibit 44 and 45. Down no, I'm sorry. So that was 47, the one that I'm inviting you to put in. 43 was a document that you reference in rebuttal. I did not catch. And no one else has seen since then. So I'm not gonna allow that in because the round of testimony already passed. That would let parties see it and respond to it. That would have been rebuttal. So we need to take out 43 and the related text in your rebuttal testimony, in the Punch rebuttal testimony.
That's 44, right, Your Honor?
no, we're talking about 43. It's the one that I forgot to
sorry.
file with
Mhm.
Punch's for blood.
Yeah, there we go. Punch 44, I think punch 10 is the same, right? Are they, or they're either the same or it's not very the same in some things. Oh, yeah, no, okay. Punch 44, there's a number of reasons why I won't accept that. It doesn't have any author, it doesn't have any reference or citation or it's from. And actually, some of it's already in testimony, this diagram. It's duplicitous of what we've already heard about, which is what spike pressure pulses are. That's in the record. I don't add more. So that and its related testimony will go out, and then 45. This, I don't think there's probative value of 45. I think the actual criteria and all the documentation that this is displaying is in the record. And like you said, you're just using this as some sort of short summary, but I'd rather just have the actual documents of the commission look at the original documents and make those judgments. So in terms of the Sir rebuttal, it didn't seem like you were adding anything to the record that's not already been laid upon the record. That they so basically I was going to strike it for being duplicative of what's already been presented. Just really restating the witness's existing position, and that's just not necessary. It doesn't need to be done because you can rely on your prior statement. Okay, so for the trustees of 435, there were a number of documents being presented. yesterday, they're supposed to be used today, at the hearing. They appear to be copies of mining, agreements, is that correct?
Correct, Your Honor. There are copies from public records of the mining leases that were available for the farmlands around the turbines in the project area from the 1960s. And the reason why I was including them is because the applicant filed rebuttal testimony from Patton on June 10th at 11:30 a.m. And page 2, line 12 of that testimony begins with the trustees of 435 County Erie, Wisconsin raised concerns regarding subsurface remediation measures recommended at 5 turbine sites in the bar report. Exhibit Patton-3, do you share their concerns? That is a misrepresentation or a half representation of the concern that I actually raised in my motion response. So my intent was to use those documents during cross-examination of Patton.
And was there any availability of those documents before today? Did you have them before?
No, what happened with those documents, Your Honor, is that I had seen them in February. And then the Iowa County Land Shark Public Records website had been hacked and all of the documents were lost. And when I went back, I couldn't recover them, so I thought I had lost them forever. What I didn't realize until I had someone help me is that I still had the temporary files on my computer. And so I had to have somebody help me restore those temporary files to turn them into those PDFs.
All right, let's hold off on that. I think when it comes to mine locations, I did have another question. Was it you, witness Metallica, you're creating a map?
Yes.
I'm sorry. Yes, sure. Thank you for pointing.
It's
Let's just go off the record for a second.
number 30.
30, okay, but I wasn't, all right, let me just. I am not sure.
Are we off the record?
Yeah, we're off the record. And just so I know, this came in on your rebuttal,
Yes, it did.
but I'd also asked you in for your direct, you might not have seen, there was a note about creating a map that superimposed the land that was about, that was related to wells.
Correct. And that was submitted. That was number 8. 8R that was submitted.
So is that one? R is the Ohio Siting Board. 8 and 8R is the Ohio Power Siting Boards. So yours is about wells. Who had the map of that mine?
Would you like the copy of it?
Yeah, so is there, do we have a location of the mines in a map? The mines and the mines and the project superimposed.
There's one exhibit that shows number 13 that shows mines. And that's what is referenced in number 30.
That's plate 2, Your Honor, from Professional Paper 309. The only map that I have seen is in Exhibit Patton-3. And that should be, I don't know that I have the TSC number, but in there, I believe it's page 97, there's a superimposed map that was created using Professional Paper 309 and the documentation found in it. And the reason then for my mining leases is because Professional Paper 309 was published in 1959, and the mines were active well beyond that. I believe it's part 1, page 97, if I remember correctly. Let me check my notes.
I have it on the screen.
And the reference point for the creation of that map is the legend in the lower left that specifically states plate 1 of Professional Paper 309.
Okay. All right, well, we'll let this play out and see how we do. So I mean, the basic intention is this map does not reflect mines after 59.
Correct.
And I think the mines that, the leases that I saw, are those leases, those documents, or are they, yeah?
Yes, they are the mining leases that would specifically be associated with the land surrounding our family farm. So turbine number 23,
And then that
turbine
was
5 and
for
24.
1960, I believe, was the dates on those.
Yes, and if it's the volume of what I submitted is an issue, those can be pared down to just 3, which would be the Allen, Bickford, and Ruth Rundle.
Okay, well, we'll leave it for questioning, and we'll see. We'll leave it for the questioning then, so that's fine, but so. So let me just check with you, Gina, your exhibit 30. Still off, yeah. It has wells, it has the
combination.
mines, I see. So it's the mines now.
And it has the references of where those boxes come from.
Where did the map come from though? It says you have.
From the
Metallica-
bar,
I'm sorry,
from the bar report, they were that topographical
Okay.
map that's submitted on the bar report.
is that noted on here? Yes, okay, good. I just didn't, there was just a lot of stuff going on.
I know, that's a very
Yeah.
busy one, but it really tells the story
Okay.
of what's going
Well,
on.
let's leave it for now, that's fine. So that's 30, and that went in on your.
So rebuttal.
Rebuttal. Oh, good. Mom, we're off the record. Do you have anything I need to know? No. Okay, all right, good. When you stand there, I get nervous. Just don't break your computer. Yeah, we're all, I've already broken enough. So. 30, so the Metallica exhibit 32, let's go on the record for this. So I just wanted to discuss exhibit 32 that's being offered by Gina Metallica. Was able to finally have a copy on my screen, and I'm. So I've just, this is being offered for, what's the timing of the offer of this? Is this for the hearing today?
For documentation that goes along with the karst information that's being provided. Additional documentation that's local to Wisconsin, specific to our area.
And was this available before today?
This has been available, but not to me.
And I guess, are you gonna be using it to respond to something, or I don't know, it's not appropriate for additional direct. Is there something you're gonna plan to use as rebuttal? you're responding to the latest statements already made on the case.
It is a continuation of the same statements that I've made in my cert rebuttal. Providing additional documentation that says similar facts. That's separate from me, but it's local to the area.
Like its sources for this are county land and water conservation departments, UW extension, USDA, Wisconsin DNR. I guess we'll wait and see what you have to say on that. I'm just double checking this list if there's any corrections that we need to review because there's so many. Could be questions about them. So
Your Honor, there were a few additional filings from yesterday as well
additional ones. Oh, did I miss something?
Yeah. by Wisconsin Policy Monitor and I believe that might be it. Oh, I'm sorry, with regard to intervener Jenkins, he offered for additional exhibits that he's labeled hankered.
Oh, the hanker, yes, that is. Let's. So I just want to be clear, were there any from WPM or?
There are,
There are.
yes, a number from WPM as well. There,
Well, I think,
there were 10 additional exhibits submitted by Wisconsin Policy Monitor.
yeah, so looking at the exhibits that RJP is offering or will be using, those will be intended for cross of witness anchor, is that correct?
Yes, all of those are cross exhibits.
So how are they cross exhibits and not something you could have filed previously?
Because there's no direct testimony related to these.
But these are studies that support your position. Did they not have gone in and direct to support your position?
The studies, the items work together, okay. So Mr. Hankard says in this transcript here, he says that there's no studies on sleep. So the significance of these studies is they're specific to sleep. That the transcript says there's no studies that said that wind turbines are bad for sleep. These are all published peer-reviewed studies that say wind turbines bad for sleep. That's the
Does he
impeachment.
not make that claim before Servo? That's what, I think that's what got me curious about it, because I think and he may not have only talking about other things, but he has already talked about sleep prior to this. Should have gone on in an earlier way.
And I believe he's referring to the transcript, and that's dated 2023, so certainly.
Right, the transcript's dated 2023.
The transcript of this, well, sorry, just a second. So in your first exhibit that you want to use for crossing Hanford, the transcript, you're talking about this meeting on July 6, 2023.
Yes,
Okay. But in this case, as he mentioned, sleep as being something that's not affected, that wind turbines don't affect.
I don't recall.
Certain. Yes, he has, Your Honor. That has been the subject of much testimony in this proceeding.
So I think if that's the case, that could have been addressed by your witness directly through rounds of testimony, bringing up these studies in response, right?
If that's the case.
I was gonna search his testimony, see if like the word sleep comes up.
And Your Honor, I would say also, our witness, Dr. Ellen Logan, deals with sleep in detail.
Well, just for example, direct VHW Hanker 9. Line 18, Hanker saying furthermore, numerous studies of the potential health impacts from wind turbines have examined the effect of infrasound on sleep and health in general, and all have concluded there is no evidence of impact of any kind from wind turbine infrasound. So is your argument not based on infrasound, or is it that may be a distinction?
There is a distinction, so.
But in the documents. In the documents.
The documents are not specific to infrasound, they're general to wind turbines. So. There is, from our perspective, an issue with infrasound and sleep, but there's also an issue with wind turbines and sleep. And I believe that all of
Okay,
it.
but Hanker is the sound engineer, so it needs to be sound. To ask him, right?
Yeah, infrasound, SPPs are within the infrasound range, they're at the bottom of it. And the
Right,
infrasound
that's
range
not-
is within the range of sound.
I understand your position on
Okay.
that. I'm just saying, let's forget it. I'm just gonna talk past each other.
Okay.
I guess I'm not sure why your witness couldn't present these before, if these were important articles to raise and then have parties be able to take the proper time to respond to them.
We have addressed the issue of sleep elsewhere. I believe that this goes to Mr. Hanker's credibility. The combination of the exhibits is aimed at credibility.
Your Honor, if I may respond.
Yeah.
We received these articles, these documents yesterday at 1 o'clock. My witnesses have not had a chance to review them. We received over 500 pages of late filings yesterday that it would be patently unfair to allow it in these proceedings. If however you're inclined to allow it, I would suggest that my witnesses be allowed to hear the testimony on it and then rebut it in rebuttal testimony.
Yeah, I don't think there's gonna be any testimony. I think it's just I don't think there's a way to get it in on being sponsored by someone if they're correct.
And certainly these are not things that Mr. Hanker can lay foundation for either. It's not familiar with a study from Northern Iran.
I believe that Mr. Hanker could lay the foundation in that I would ask him to agree that these are peer-reviewed studies. He could look at where they're from.
He would be purely speculating.
So this is what I'm gonna say, that the very creative way of presenting this transcript where he references sleep and then have articles to present to impeach him about that statement, but none of this is in the record at the moment. And it would have been much easier and it would have worked within our process if you had a witness who could have just sponsored these exhibits and could have spoken to the issue directly. And then if the applicant needed to hire another expert, they could have to properly rebut. But at this point, I can't allow this in. We can't open up this case to this issue to the extent it's not already opened up to it. And there's plenty on this issue to the extent we have already heard a lot on sleep disturbance and spike pressure pulses. Let that evidence will be before the commission, it's laid before them, they can judge it. But to impeach, to bring in documents that could have been used substantively, usefully. Simply to impeach someone, when it doesn't even seem like we may be talking about the same expertise or experience. I don't want to waste time, so I'm not gonna allow you to.
So Hankered 1 through 4, that
Oh,
were.
it's not anchored one for. It's the exhibits being used, offered by RJP to cross Hankered will not be allowed.
Thank you, Your Honor.
And so we do have documents from, WPM.
Yes.
Did I get those emailed to me? You're gonna
I
have
can
to
hear you,
email-
but you're gonna have to speak in the microphone. Thank you.
I believe we sent it to the whole services.
Go off the record.
Here, I'm just looking at the email right now, and I'm not sure that Your Honor was on it. I can forward it though.
Okay, let's. You like shows up?
We need mine back. Okay, let's do it. Okay, so I have on the screen share, the email that Attorney White's has, forwarded to me. Sent by, Wisconsin Policy Monitor LLC, pre-hearing materials. It's the disclosure that we require for the parties and commission staff to serve each other and email to me. The service should be to the service list. I want to point that out to everybody, because that's important. Service list is the document, the list of contacts we use to make these official, well, service in general and official communications. When the commission will go to the service list. So I don't recognize this email. I don't see me on the list of recipients. And just by looking at the number of emails listed, doesn't appear to me that that's the entire service list. But you know, maybe it's not all showing up, but just wanted to note that. So having not received this, parties did get it, so that's one major hurdle to overcome in terms of make people aware. I don't get it, it just makes it harder for me, so just note that. So there's a number of people they wish to cross, which I was not aware of until now. And the documents, so there are a number of documents. The 10 documents, Attorney Olson altogether.
I believe so, yes.
And so I see one at least is already an exhibit. It's the first one that you said, the ISO 9996 standard as an exhibit and
Punch 35.
the rest of them, you were expecting to use these documents on cross?
Yes.
Yes?
Your Honor, if I could just point out one other thing, I think the first one, the Vermont
is the same as Brown 12.
I don't, I'm sorry, it was off the record. So first one, I have the ISO, maybe I'm just looking at it.
Oh, I'm sorry. I was looking at the list rather than the attachments.
There's another one. Oh,
It's in the body.
oh, okay, so that's,
I believe, but maybe Mr. Olson, you correct me if I'm wrong, but I think that's Brown 12.
it's definitely in the record, yeah.
I believe it is from.
Okay. Let's get on the record. So in a similar vein, can you explain how these are cross exhibits and not something that should have been presented by your witness on direct?
Your Honor, to be perfectly candid, I don't doubt that they could have been presented by a witness on direct. If they would have, we presented the ones with Ms. Brown's testimony that we thought were barely within our expertise, and even that drew some objection from the other side. So my understanding from looking at the order was that we were allowed to disclose exhibits that would be used on cross the day before, and if that was a misunderstanding, then we can't use them. That's all there is to it.
Yeah, well, let's see how this plays out on cross.
Your Honor, but may I briefly address this?
Yeah.
Again, these are 10 additional exhibits. One's an appraisal from 2005, one's an appraisal document that clearly addresses property valuation issues that could and should have been raised on rebuttal. Our expert has not had an opportunity to review these. I don't think it's fair presentation on cross-examination, given the order facilitating matters.
Well, what I would say to that is I think the two, that you're referring to are the Wyman and Mothorpe article from 2018. And the forward wind report. That was the appraisal consulting report with an effective date of May 31st, 2005. It's possible, and I believe it's very likely that, I'm not sure quite the pronunciation of the gentleman's name, but Maroos. I would like to try to cross-examine Mr. Maroos on those two documents. If he doesn't recognize them, then I wouldn't be able to cross him, and that's the risk of doing something like that on cross. He may simply say, I don't recognize these documents, but if I would say, are you familiar with this study? And he says, yes, then I would be allowed to cross him. So that's my understanding of how that works. And I don't think, given that representation, I don't think it places an unfair burden on anybody, because if he's already familiar with those documents, perhaps he's very familiar with them. I will see it. He said in his appendix to the application that he had written on and studied transmission line impacts before, so he may know about them. If he doesn't, that's the risk we run.
So long as they're limited to the uses that have been represented, I'm comfortable with that.
Yeah, that's all useful thoughts, right? Okay.
Your Honor, if I could just add one more thing, just so that everyone is on the same page, I think Brown 13 is also one of the articles. That's the response to noise emitted by wind farms. So I just wanted to identify that, so if they are being used on cross and it is an existing exhibit, we can use the correct.
Okay, and I just closed your email. Just off the record, there's another ISO document I just happened to notice. Was that
I
another?
believe it's punch 17.
Oh, there's the 1999, the 9996,
2631.
2631 is punch.
I won't just double check.
Okay, yeah.
Punch 40 and punch 35. Punch 35 is ISO 9996. Punch 40 is ISO 2631-1.
Thank you.
And then 17 is something else. So there could be a duplicate.
17 is World Health Organization's noise guidelines.
Okay, that had a date on it. Okay, so Right, so if we can refer, so let's just try to remember if we can refer to documents by their designated names, if they're being offered for the record already, so. Any exhibit, you should use the exhibit name when we're talking on the record. This way, when the commissioner reads the transcript, they'll be able to go to the exhibit, they won't have to think of, well, the who study 1999, who filed that, what's the exhibit number, let me try to find it. And just so you know, they're gonna get this document, so this is why work hard to make sure it's as accurate as possible. But they're gonna be able to see, at the end of the day, this will be converted to a document called the received evidence list. For those of you not familiar, right now it's offered evidence. The received evidence list will have all the final versions of the documents, all the corrections that you filed on my direction. And the documents that have been verified here today will be reflected on the list, the correct PSC numbers. And then they'll be able to click on those and read the record. So that's why it's important to use the names we've agreed to use, the ones I've told you to use. It's another way of putting it. And use those names, but also you want to use the correct version. So, there's still documents on this list that if you go internally, look at the document, they say like Jenkins, direct Jenkins. Let's try when we're speaking today to use the correct party identifiers. So we don't confuse the reader, the commissioners who will, your main audience. So Johnson's direct is direct DHW Johnson. Johnson's exhibit is exhibit DHW Johnson 1. They can find it nice and easy. So let's try to make habit of that. It's gonna make some adjustments. So I'm gonna ask then, while we're off the record, any corrections or mistakes I've made to the list? Or did I not indicate the right document that's currently being offered, or did I
Your Honor,
forget something? Yeah,
Hell's exhibit 1 through 5. Here to be missing.
I'm striking those. Oh, they're out. They're not on the list, really?
They aren't.
Oh, yeah, look at that. All right, I'll just make a note of that.
Thank you.
Should have been a little more assertive about that.
I identified it in the pre-hearing.
Oh, yeah,
email, but
those, well. I would
There's a
have
lot
as
of those,
close as
so-
I can.
yeah.
Okay, anything else like that? That's a good example.
Well, tangentially related is the issue related to our witness, Dr. Howard.
Okay. What did I miss?
That is the witness from Quantum that you ordered us to show cause as to why it was not submitted on direct.
Yeah.
So we filed a document outlining various portions of direct testimonies in addition to Ms. Brown's testimony that it's responsive to. So I believe, and I hope that it can be admitted as proper rebuttal testimony, but I don't believe it's on the list.
Okay, yeah, I thought. Oh, okay, I guess I thought maybe we addressed that at the last hearing, but I think maybe we, oh. Yeah, I had, okay, let's go on the record. So I did ask the applicant to address why rebuttal BHW Howard was filed as rebuttal and not direct, given the contents. And I think the issue is that we had stricken something to which Howard was referring to as rebuttal.
Which I
And,
believe now is in.
and now it's in, so there you go. So that's why I wasn't even gonna even raise it, but thanks for bringing that up. So we're all good with Howard, yeah. Okay, anything else we can do off the record?
Your Honor,
Off the record, yeah.
so, I guess Mr. Jablonski and I for Jenkins 5 agreed that there's an error and it needs to be refiled. And I just wanted to note, I think Mr. Jablonski confirmed in his email that we did intend to refile it after the hearing. There's just some highlighting that was left out.
Left out, okay, hang on just a second. Well, is that highlighting that you intended to add to the original document?
It was highlighting that was in the original document, and when we printed it to PDF, it didn't transfer.
Yeah, I think it was an inadvertent happening.
Okay, so So just so you know, that's the meaning of replacement exhibit that would be due yesterday, but there's not really gonna be any issue with that, I don't think, so. But that's a good example as to, oh, this exhibit has a mistake in it. Let me get it to everyone before the hearing. And then you'd wanna serve it, tell me. And refile. Yeah, you can refile if it's that situation, so, people ask me, what does that mean, refile the exhibit? That's exactly what I'm talking about, so yeah, I think if you wanna, so I don't. Do I need to hear any objections to that on the record? I don't think, yeah, okay. So Jenkins 5 will refile with highlights, and why I asked is, you're not supposed to be adding any markings to an original exhibit, just wanna let everyone know, so. So I will tell, if I see a highlight, I'm most likely gonna say, hey, take the highlight off. Because we don't wanna confuse what was originally filed. Okay.
Here and I have just a few more housekeeping issues that we could address off record.
Okay.
First of all, when we're questioning witnesses, how would you like us to display documents? Do you want us to show paper copies? Or will you put them on the screen?
I'm gonna put them on the screen, this screen, the resolution isn't. Guess it's okay, can everyone in the circle see this? I mean, I can make particular pieces bigger if we, get to a certain section or piece, so. We'll see if that works, and then we'll take it from there. This is good, because then the Zoom people can see it as well, it's being shared on Zoom. Everyone will have a copy in front of them.
And then the last issue I had was just for the public hearing next week. I understand that we have an obligation to make witnesses available with substantial knowledge about the project. I just want to make sure we're covering our bases. If there are particular witnesses that folks would like to be present at the hearing, we can consider that. I just want to make sure that we're fully prepared for that.
Yeah, what do you mean, like folks, the public? guess-
Or you, your honor.
I'm only gonna say what I've already said in the order, so I'll leave it up to you guys to take the chance that you satisfy the public's curiosity. Okay.
Yeah, Your Honor, the interveners have requested a list from the applicant of the specific witnesses that would be able to answer specific topics that we had. And I submitted one to the applicant on Thursday and asked for a response on Friday. Friday, I'm not sure what I got, but I resubmitted, or I made another request to you, and I've got the IRF document. I had a copy here and it's must have moved somewhere. It's gone.
Yeah, but I have a feeling I know how you feel.
Yeah. I can give you the ID number of that if you.
Okay,
It was
so
filed on the IRF at 7:45 on Monday morning.
just a second.
I've got the number.
So go ahead with the PSD number.
549633.
Okay, so correspondence. So Attorney Polakowski, are you familiar with this letter? Any comments?
I don't know what else I can say other than, of course, all of the witnesses are free to examine our witnesses with regard to the topics contained in their testimony.
Yeah, so we're still off the record, but I mean, our basic process is just the witnesses who've spoken on these topics are available for questions. Would it have been easier to get the list? I probably, but I don't require people do that. And in terms of excusing a witness, you'll have an opportunity to question each witness if there's any indication that there's a person that we need to recall. And I don't think the applicant's gonna have a problem recalling when it's probably to their benefit to do that. But I think we're pretty distinct. These witnesses are pretty distinct, so I don't know if there'll be too much crossover with topics. Hopefully we'll be able to catch the right person for your questions.
Thank you, Your Honor.
So so let's just go through the list one more time with any questions or comments on the offered evidence list. I'm probably gonna need to reissue something with instructions because there's so many corrections and organizing the filings that. I use it to track how you refile, so I don't know. What I'm looking for, I'm sure you don't know what you're supposed to do, so. But any questions about what you've seen on the offered evidence list in terms of the corrections?
Your Honor, I just had a question about there was, within the last week, I think it was, that you had made some corrections to some things. And said that we should wait until after the hearing to refile those. Is that still correct?
Yes, and you mean, when you say these things, I think you're talking about your direct and.
Yeah, you sent a list out and you made comments about, and
Right.
I've got mine all done, but you
Yeah.
said to wait till later.
Right, because now there's been new changes and there's
Okay.
been, we've been here today to discuss what we're accepting, what we're not, so. I can. So you're supposed to have 3 business days to refile. I don't know. I can try to issue an updated list and then have you. Give you 3 days from when that list was issued to refile, if that's helpful. Let me think about that before we adjourn. I think that may be useful, but I think I don't think things have changed all that much. There's a lot of the things we've just discussed today. In addition to the list that you were given before. Let me think about that, but I think, but basically, yeah, you need to refile after the hearing. That's the idea, using the comments that I have on the list.
I was just confused because just a little bit ago, someone was saying we had to turn in the refile thing within the last day or so, and
That's a different thing, so. If you noticed a mistake on one of your exhibits. I asked you to file that by yesterday,
okay.
but the testimony is something that we need to, it's more simple, and it's something we want to have the real document to talk about at the hearing, so it's time to get that in. The testimony, it's more technical, those details we can fix after the hearing, so you don't have to bother using your time to prepare for the hearing to fix those technicalities.
Thank you.
That's why there's a difference there.
Thank you.
So do your best, and I'll be able to get back to you and tell you need to make more changes, or you misunderstood something on the list. Anything else for the list? Okay, so I know we have some requests to take witnesses out of order, one of them being a DNR witness. Is there any other witnesses we need to address? Them going out of, and let me just say the normal time, I think we mentioned this before. If you go to the offered evidence list, that's our order of witnesses as well, so we'll take the applicant first and then do interveners in alphabetical order. The witnesses that you have, if you have more than one witness, you can call the witness in whatever order you want. The parties just go in order from the offered evidence list. But if we need to jump someone up or down schedule, we can do that.
We had requested that Dr. Howard appear first thing tomorrow morning. He's in Europe, so it makes the timing a little difficult.
Forward, all right. And then Mathewson will try to get him out as the first witness, if no one has objections to that.
No objection.
So, any witnesses we don't have cross for? It's like we got it, I think after seeing that WPM email, I think we've got everyone's here for cross, right? Because I can, so just so you know, if there's no cross, I can excuse you and you can the party can decide to have that person verify their testimony by affidavit and not be here or, you know, can be gone, it can be excused. So doesn't look like we can give that. That,
I think witness Matthews does not have any problems, which works out because he also has the conflict, so.
okay, well, it may be harder to make the affidavit than just come up.
Well, that's what I mean, so if we just start with witness Matthews,
So we're done.
I think
All right,
we're good.
That's good. Usually I don't mention this till like after the hearing, then people say, I didn't have to sit here the whole time. Well, I told you in your email.
Your Honor, is witness Cal here?
Yes, I see him. You wanna identify yourself, witness Cal? Tell you the room here. There you are. Okay. You got questions for him, I guess, huh? All right, well, there you go. Get ready. Okay, so I think we can take Matthewson. Matthews, sorry. Yeah, that's a different case, right? So why don't we call you, witness Matthews, come on up. We'll just take your testimony and, we'll see what other timing we have.
Yes, yes.
All right, have a seat. All right, let's get on the record. Swear you in, raise your right hand. You swear or affirm the truth, the whole truth, and nothing but the truth? I do. All right, go ahead.
Thank you. Good morning. Could you please state your name for the record?
Weston Matthews.
And witness Matthews, what is your position and who do you work for?
My position is a environmental analyst and review specialist for the Wisconsin Department of Natural Resources Office of Energy.
And how did you become involved in this docket?
I became involved in this docket as the project manager for the Department of Natural Resources.
Okay. Did you?
So
Did you file or cause to be filed direct pre-filed testimony in this matter?
yes, I did.
And are all the assertions that you made in that pre-filed direct testimony true and correct to the best of your knowledge?
Yes.
Do you have any additions or corrections to make to your testimony at this time?
No.
That's all I have. With that, the witness is available for cross.
All right. Good questions?
I do have some questions.
Okay, good to know. All right. So introduce yourself to the witness.
I'm Gina Metallica. I'm a landowner in the area. And one of the concerns I have is all the waterways in our area. Are you familiar with Susan Swanson, who wrote Wisconsin Spring Resources? An overview. It's one of my exhibits.
No, I'm not.
If we could pull that up, exhibit 28.
We have it on the screen.
And we can go to page 2, figure 1.
Your Honor, I'll object to this line of questioning. It's lacking foundation. Witness has just testified that he's not familiar with this document.
I mentioned about the waterways in Wisconsin. I wanted to show an image of the waterways in Wisconsin in this particular area. At the bottom of that page 2, it has.
Well, just a second. So we have an objection.
And Your Honor, I would join in that objection. I think witness Matthews did some direct analysis of this particular project. I think that might be a more appropriate line of questioning rather than just a general map from an article that he said he was not familiar with.
That blue map is what I'm showing, or what I'm referring to, and the heavy blue area on the lower left is an indication of all the springs and waterways that are the highest in the state of Wisconsin and the highest concentration in the United States.
Okay, so I think if you can ask him questions based on his expertise,
Of an environmental.
without referencing the document, he's not familiar with it. Let's see.
With respect to environmental issues, what have you seen with the groundwater issues in southwest Wisconsin?
So for this case, my review involved the waterway and wetland evaluation and as well as the impacts. So
Not the groundwater
not groundwater.
and not the impact of the groundwater. In my area of interest is the impact on groundwater. The applicant has to do significant trenching in our hilly area, 44 miles of connector circuits. Can the heavy rains cause issues to our environment, to the excavated refill trenches? And then getting into a groundwater in our environment?
Again, for this case, I looked at the waterway and wetland impacts. The applicant does propose trenchless burying, and trenchless is installation via collection lines via trenchless is not regulated under DNR chapter 30 or 281-6.
But that's not for all the areas that are required for the for the conduction line. For some of them, there will be that type of trenching.
Your Honor, if Ms. Metallica is referring to some specific reference from the application, that might be helpful.
Okay. Yeah, I think you did cite something in your testimony, if that's, if there's a reference to the application on there about that.
I will have to get back to that. So the one last question for environmental issues. Is there any existing policy to prevent contamination of waterways from runoffs and trenching?
Here, repeat the question.
Let's read it back.
I-
She's gonna read it back. This is good practice.
So one last question for environmental issues. Is there any existing policy to prevent contamination of waterways from runoffs and trenching?
Again, for my direct purview of this project was proposed waterway and wetland impacts. The DNR, the applicant will have to get a stormwater erosion control permit, which has standards. It's outside my review, but it is an applicable permit.
Those are all the questions.
All right. Other costs? More questions for the witness?
I've got just a couple of questions, Your Honor.
So just introduce yourself.
Good morning, Amy Hunt, intervener, representing the trustees of 435 County Highway Erie. On page 3 of your direct testimony on line 17, it says, how did the applicant evaluate the project area for the present wetlands? And the answer, part of the answer, starting on the sentence starting at the end of line 19. The field delineation occurred in June 2024. I'm assuming that is when you guys were on site in the project area. Is that what a field delineation is, or can you explain what that is?
Field delineation is when the applicant's consultant was out on the field.
Okay, were you present with that field delineation occurred?
No, I was not.
Are you aware, was June 2024 considered to be a month that had even an average rainfall or moisture level?
I do not know.
Okay. So then when they're saying that they identified wetlands in June of 2024, without knowing how much precipitation had been occurring in the area, is there a possibility then that there's additional wetlands in the project area that couldn't be identified due to the lack of rainfall or potential lack of rainfall?
I have to recall the applicants, I'd have to refresh their delineation report, their field delineation report.
Is that field delineation report, is that included in the application?
Yes.
Let's go off the record. I think is that appendix 5? Data tables.
Yes.
Okay, so it looks like we have, so let's get on the record. We do have the Badger Hollow Wind Energy Center Field Wetland Delineation Report, and it's appendix 5 of the application. So that's a document we can refer to refresh your recollection. So, Ms. Matthew, you recognize that document?
I do.
Okay. So what was the question?
The question was, witness Matthews, because you were not present during the field delineation, you relied solely on this document for your testimony?
I did not rely solely on this document.
What were the other sources of information that you used without being present, physically present within the project area?
Can I refresh and review my direct?
Yeah.
So along with their delineation report, we have, the DNR has available information on our website, public information. So that DNR surface water data viewer contains layers with wetland information, map soils, indicators, map wetlands, Wisconsin wetland inventory layers. So kind of cross compare, look at what they provided and look at what we have on our end.
Can you then explain, when you're saying that there's a database, there's a Wisconsin database of recorded wetlands, basically put that kind of together. Can you explain the process of being a designated Wisconsin DNR wetland to be in those databases?
The wetlands on our DNR database, it's more of a mapping, and it's just a tool. It's not a definitive boundary, so it's a starting point. So it's just used to help customers that call into the DNR, applicants as a starting point to kind of then help the applicants and help review for wetlands.
Okay, so the two documents that the documents that you use were the field delineation report, the existing DNR database without any field observations. Is it safe to say then that there is the potential that there's additional wetlands within the project area that have not been identified?
Within the project area, do you mean the field delineated corridor or the entire project area that was desktop?
That was
Desktop reviewed.
Okay. Maybe this will provide clarity, any place that there would be project infrastructure, including collection lines, wind turbines.
So permanent fill.
Meaning, based on the evidence of what you reviewed and stating that the DNR database is a starting point of wetlands, it's not a definitive, let's say Bible, right? It's not all inclusive, just a starting point. And then the additional information was the field delineation report provided by the applicants. But knowing that both of those documents could potentially be incomplete, is it a safe statement to say that there could be additional wetlands where project infrastructure is planned to be placed that are not identified anywhere within the field delineation report or the Wisconsin wetland database?
So based on my review as the application has proposed, there's no direct impacts to wetlands.
That are currently identified would be the differentiation, right? There's no impact to currently identified. My question is there a potential for there to be additional wetlands that are not identified?
I can't answer that.
That's the end of my question.
Was there a pending question about rainfall at the time, or is it from?
Well, I may have some redirect on that.
Okay, all right.
If there's
any more
no more cross.
Yes. I was just wondering, can you
Just
describe,
introduce yourself. Just state your name to the witness. You didn't ask questions before, did you?
no,
Yeah.
the Grice? I just had a question about how could you describe the process of the DNR identifying wetlands?
Could you be more specific?
What is the process by which you identify a plot of ground as a wetland?
So a wetland, DNR looks at a wetland, it's an area where the water is at or near the ground surface long enough to sustain aquatic or hydrophytic vegetation, and also an area that has indications of wet soils. So there's kind of three parameters: hydrology, vegetation, and soils. And that's what goes into review to look at whether it's considered a wetland or an upland.
And can you tell me what causes you to look at a particular piece of ground to determine whether or not it's a wetland?
We use the available resources on our within our mapping systems as a starting point to see. It has kind of soil information. It has the Wisconsin wetland inventory layer for areas of potential wetlands, and that's as a starting point. Wetland delineators use that material as well as a starting point, and then a field determination or delineation goes out and ground truths that information by looking at soils, vegetation, hydrology.
So if I'm a farmer and I don't want my ground evaluated to be a wetland, is it evaluated by the DNR?
That's what
I'm gonna object. I'm not sure as to the form of the question. Maybe if Ms. Grice could restate that.
Well, I'm just trying to point out that the DNR wetland determination, and my experience has been where the farmer has had to agree to having his certain piece of ground be determined to be a wetland. Is that not the case?
And I think my objection is as to foundation here, because I think we're getting away from the evaluations for the project into something discussing.
But what I'm trying to determine here is whether or not all of the wetlands that actually exist in the area, the project area, have been identified as wetlands, or if they're not labeled as wetlands on the DNR records, then they might be wetlands and they're not being evaluated as wetlands for the project.
So is there an objection to the question then?
I guess, I mean, this is a little bit asked and answered. I think a witness Matthews talked about that there's a combination of the DNR kind of databases and the desktop delineation report in combination with the field delineation for certain aspects of the project. So I'm not sure if Ms. Grice is asking about a similar question to Ms. Hunt as to whether or not that is exhaustive such that there's no possibility of additional wetlands, to which I think witness Matthews already gave a response, or if we're sort of asking the same thing over again.
I think there's still a concern whether or not it is definitive. That's why I'm asking the question.
So I think we heard what the witness has to say about that concern, but yeah, I don't know. Witness is gonna be able to answer anything further on that, so. Yeah, so we'll move on to another question if anyone has. Other cross?
I just have one quick question. Good morning, my name is Jess Polakowski. I represent the applicant Badger Hollow Wind. Are you aware of whether the applicant will field delineate any wetlands within the project, any portion of the project area prior to construction that will host permanent infrastructure.
Correct, if I could review my direct just for. Yeah, yes, the applicant stated that wetland field verification surveys be conducted for the laydown areas and all permanent structure and fill areas and at any area of proposed road expansion or modification.
Thank you, that's all I have.
So that's in addition to the existing field delineation.
Correct.
Any other cross? Oh, read.
Okay, just a couple of brief topics. First of all, you were asked some questions about runoff. Would it be fair to say that that is more stormwater permitting? That wasn't something that you reviewed in looking at wetlands and waterways?
Correct.
Okay. And second question, when we were talking about the combination of field delineation, the desktop delineation and looking at all that together, is it fair to say that your assessment looks at the possibility of wetlands over more than just a distinct snapshot in time, such as June 2024 that you were asked about, that those data sources look at things from across a variety of time?
Correct.
And then lastly, I think ALJ Newmark has it pulled up on the screen. We're looking at, let's say it was Appendix 5, the wetland delineation report, page 14. There's a chart that shows precipitation. Do you remember reviewing that?
I do.
Does that answer the question as to whether or not June 2024, when the field delineation was done, was wetter or drier than average? You need to get closer to read some of that small text, certainly feel free to. I think you need to go down.
I had it perfect. What was I thinking? The 4.2.
It's page 14, yeah. I can also show the witness on my computer if that would be easier.
Hang on, I'll get this. It's showed on the entire page. If we could scroll down. Let me know. Scroll down for you.
Yeah, scroll down. I believe it indicates normal conditions.
Okay. Thank you. I don't have anything further.
And witness Matthew, just when the applicant will do the subsequent field delineations that you just answered question about, would you expect it to be what type of precipitation would you expect there to be in the field at the time when they do that new delineation?
I think when they, as part of the field, it's you kind of. Part of a field delineation is you look at when, before you go out, or is it drier conditions, wetter conditions, or within a normal range, and that helps. Determine the subsequent field delineation, so it's depending on when they go out, they have to document as part of documentation for the full review of the. Field determination.
Oh, it's just so I understand, so that the field delineation doesn't depend on precipitation, it will just indicate what the precipitation was and then make a determination based on actual.
Correct.
And if I could just ask one follow-up from that, depending on whether it's the precipitation, are you looking for different things in the field as far as indicators of wetlands?
Correct.
Okay.
All right. That's great, thanks, then you're excused.
Thank you.
We have applicant witnesses, it's noon, so let's go off the record. We want to get you for a break.
do a half hour and then come back. Let's make it, I'll make it 12:30. I'll be generous and then you'll suffer later after that. All right, thanks.
Yes, so then 2.5 each. Good. Yes, yes. Do you need it?
Yeah, just.
Sure, I can grab it.
Well, that's what happened before. It's I had it off and then.
Yeah.
As the judge knows, I'm always.
All.
Your Honor, if it's all right with you, I had not planned to call my witnesses in this order, so just in terms of presentation, is that all right with you?
That's always okay. Up to you guys, who you wanna call. Well, not who, but when.
Way.
All right, let's put on the record. Just on time, so let's call our first applicant witness. Nick, in this thing. Okay, get started. Moving out to learn.
Thank you, Your Honor. Badger Halloween calls Griffin Turner.
What was the first name?
Griffin.
Oh, I do want to check microphones just before.
Yeah, I don't hear you.
I can fix that, I think, then we can see whether there's issues in the bag. Sure. How about in the back? Better, and it's a little. How about now, looking back now?
That's.
And how about, let me try and put in here. Close.
That's.
You.
You're gonna move your microphone a little better. Better one.
All set.
All set, just swear you in, raise your right hand, you swear or affirm, don't give a whole truth, nothing but the truth.
I do.
All right. Go ahead.
Good afternoon. Please state your name for the record.
Griffin Turner.
Where are you employed in what capacity?
I'm employed by Invenergy, the applicant, Badger Hollow Wind Farm LLC, and I am a permitting specialist on the renewable development team.
Have you prepared and caused to be filed in this proceeding direct testimony consisting of 29 pages and one exhibit?
Correct.
Do you have any corrections to that testimony?
No.
Is the information contained in your testimony and exhibit true and correct to the best of your knowledge?
Yes.
If I asked you those questions set forth in your testimony today, would your answers be the same?
My answers would be the same.
I move for incorporation of Mr. Herder's testimony into the record and admission of his exhibit.
Okay, and so before I ask about that, let me announce that all the documents listed on the offered evidence list that we discussed in the morning as being acceptable pending the corrections and pending witness verification are in the record. So you don't need to offer them when the witness takes the stand. Of course, this case is so crazy procedurally, it might not hurt, but I think we can assume that the documents you see on the list will be on the record in some form or fashion. We just need to have the verifications confirmed. So with that.
With that, Mr. Herner is available for cross-examination.
Okay. So I don't have a complete list now who has crossed, so let me just ask them cross for the witness. Go ahead.
Good afternoon, Mr. Herner. My name is Eric Olson, and I'm here on behalf of Wisconsin Policy Monitor LLC, and I would like to ask you a few questions, if that's okay.
Yes.
First of all, I understand that your testimony in this case gave a overview essentially of all of the testimony from the applicant. Is that fair?
I gave an overview of the direct testimony, the rebuttal.
Would it be a true statement that the applicant does not expect to present any expert opinion that the Badger Hollow Wind Project as a whole, including turbines, transmission lines, and all other infrastructure, will not cause any type of sickness to any people in Wisconsin?
Could you please repeat your question?
Let's read it back.
Question, would it be a true statement that the applicant does not expect to present any expert opinion that the Badger Hollow Wind Project as a whole, including turbines, transmission lines, and all other infrastructure, will not cause any type of sickness to any people in Wisconsin?
I am not a medical doctor. However, we do have Dr. Jeffrey Ellenbogen here available for questions.
Do you expect her to present the expert opinion that I just stated?
Objection, foundation, calls for speculation. Dr. Ellenbogen is here to testify and will be subject to cross-examination.
Sustain.
On, which experts, if any, will present the expert opinion that the project will not create any undue individual hardships?
Your Honor, I'll object to this line of testimony. Testimony as duplicative, the testimony is in, the evidence is what it is, asking this witness to summarize various aspects of the testimony is unduly duplicative and unnecessary.
Any comment?
I think it's fair cross. That was page 13 of Mr. Herner's direct at line 3. He stated the project will not create any undue individual hardships. And I'm asking him which experts they're going to produce that will testify with a reasonable degree of professional certainty that the project will not create any undue individual hardships.
So I think he can answer that question. So
I believe we have demonstrated in our application compliance with the statutory requirements of PSC 128. And we have a group of experts that will be able to support the fact that the project will not negatively impact or create any individual hardships for people living in the project area.
Is that the greatest degree of specificity that you're able to answer the question I just asked as you sit here today?
Can you please repeat that question?
let's read it back.
Question, is that the greatest degree of specificity that you're able to answer the question I just asked as you sit here today?
I believe it would be the previous question. I
You want the previous question?
think that's what needed to be read back.
The one he answered?
No,
Because I only have,
no, I think we're right.
okay, the very last question I have is that the greatest degree of specificity that you're able to answer the question I just asked as you sit here today?
As stated in my testimony, Badger Hollow Wind has made and is continuing to make significant good faith efforts to mitigate and eliminate any potential concerns that may arise from the project, and Mr. Cooper Johnson and Brandon Davis can speak to that more.
Would you agree that before it is possible to state with certainty that the project will not create any undue individual hardships, the location of the turbines would have to be decided.
I'm not sure I understand the question. We have proposed turbine locations.
Would you agree, as we sit here today, that the applicant has proposed that the location of each turbine could be altered as much as 250 feet in each direction?
That is correct, and I believe commission staff, Olivia Pullman, agreed with that in her testimony.
Do you think it is it your opinion? Well, let me ask you this. Is it your opinion that it's possible to analyze whether a project of the scope of the project that we're analyzing here today will cause any individual hardships when the location of the turbines that are proposed to be constructed could each vary by as much as 250 feet in any direction?
Any potential turbine shifts will maintain compliance with PSC 128, setbacks, noise, and shadow flicker thresholds.
Would you agree that one or more persons may become sick as a result of
Sorry, but
sick as a result of the project?
I am not a medical doctor. I cannot speculate on people becoming sick.
Hypothetically, if a person became sick as the result of project, would you agree that that could constitute an undue individual hardship?
I'll object. Foreign foundations, calls for speculation.
yeah, sustained, there's just too many variables in that.
Mr. Herner, as we sit here today, would you agree that the applicant does not at this time have all of the property rights that it needs to construct the project?
I do not agree with that.
On the topic of public interest, you opined that the Badger Hollow Wind Project is in the public interest considering safety factors, correct?
That is correct.
When you made your opinion that the Badger Hollow Wind Project is in the public interest considering safety factors, what did you define as the public?
The state has set setbacks, noise, and shadow flicker thresholds, and we are compliant with all of those. And I believe that sufficiently addresses safety.
So your opinion was based on compliance with the specifications that are delineated in state statute and administrative code that you just cited, correct?
Correct.
When you analyze the potential for the project to create individual hardships, did you consider an individual hardship as a safety concern, or did you look at it as a separate factor.
I believe the project is properly cited and safe.
In, in your capacity as Invenergy, which is the owner of Badger, well, okay, let's. Your title is Senior Associate Renewable Development Permitting at Invenergy LLC, correct?
That is correct.
And Invenergy LLC is the sole owner of Badger Hollow Wind Farm LLC, correct?
I'll object to the extent that it calls for a legal conclusion.
Well, it's,
Overall. Yeah, in page 1 of his testimony.
Invenergy Wind North Development North America LLC is the sole owner of Badger Wind Farm. Badger Hollow Wind Farm LLC.
I see, thank you. In your capacity as Senior Associate Renewable Development Permitting at Invenergy LLC, are you asking the Public Service Commission to accept the representation of your employer that the project is safe in making their decision as to whether or not to issue a CPCN?
Object to form that assumes facts not in evidence. Invenergy LLC has not submitted any opinions in this docket.
Okay. System.
What is your capacity, if any, in relation to Badger Hollow Wind Farm LLC?
I assisted with the drafting of the CPCN application, as well as assisted with coordinating experts, consultants to prepare application materials.
And you also submitted testimony on behalf of Badger Hollow
That
Wind
is,
Farm LLC, correct?
that is correct.
And are you asking maybe a representation that the project will be safe? He accepted at face value by the Public Service Commission for the purpose of deciding whether or not to issue a CPC.
Our application and its supporting materials have demonstrated that the application will be safe, yes.
So that's the extent of the basis for your opinion, fair?
Object to form, so I'm not sure what. That's the extent it's referring to.
Rephrase.
Yeah. So that the bases that you just described are the extent of the bases for your opinion that the project will not create any individual hardships, and as you previously testified, will be safe. Is that a fair statement?
That is a statement I made.
Okay, thank you. I have nothing further.
All right, so that's cross. Oh, do you have another cross question? Okay.
Yes, if I can.
Just
Yeah, my name is Leonard Reagan. And can you tell us which turbines Invenergy is going to use for the Badger Hall project? What I'm really asking is, will it be the best 162?
I'm sorry, what would be the best?
That's the best as a manufacturer. The bestest, the big.
Bestest.
The final turbine model has not been determined yet.
Well, how can it not be determined if it's, they got 19 turbines and 118 megawatt project?
In our application, we provided the bestest turbine as an example and stated that any turbine used would be of similar size and specification.
So it would have to be the best of 162 because that's a 6.2 megawatt turbine. 6.2 times 19 equals 118. I don't know, there's other, I see in your application, there are other turbines, but they're only, the GE 38 is only 3.8 megawatts, so you need like 30 some
So
turbines.
is there a question, you're asking the witness if there are other alternatives? That they're
Yes.
considering?
Well, they do have it in the application, but it appears that you're going to be using the V162.
A final turbine model has not been determined at this time. If we end up using the V162, that will be the turbine we use, or we will use a turbine of similar size and specification.
So if the PSC approves it, then you just say, oh, we're gonna use the V162.
Objective form.
This game, can you rephrase that?
Well,
Just slow down a little, so, so I can, yeah.
okay, so the PSC, okay, just,
We're off the record for a second. Is your mic on? Is that
Oh, I'm
your mic?
sorry.
Yeah, there might be a little issue with that. Oh, good. And then. Yeah, it should be lit up great.
so in the case that the PSC would approve it, then you're gonna tell us to be 162, or it's gonna be, the GE 38. Is that how it works?
Or another turbine
Oh,
of
another
similar
turbine.
size and
Okay, we
specification.
can't talk over each other. One at a time.
I'm sorry, or another,
Turbine of similar size and specification.
thank you.
So just so I'm understanding, the GE turbine that's in the application is a much smaller capacity. That's just.
Yes, it's only 3.
No, wait, what? Let him answer. Let him answer.
That was the turbine, we provided a range of a large turbine and a small turbine. That was the small turbine that was being considered to potentially be utilized in the project.
But as you sit here today, you would only use a turbine that's of similar size capacity as the Vesta.
Or of the GE, we have not determined a final turbine model at this time.
Because, well, but you mentioned same capacity as the Vesta, is that true or?
Yes, or any turbine included in our application.
Oh, okay, so it could be the GE, which is much smaller.
Correct.
Okay, so did you have another question?
Yes, but you only have 19 turbines location at this point. So whatever you select, isn't it reasonable to say it's gotta be 6.2 megawatts, whether Vesta makes it or GE makes it?
I cannot speak to the final turbine model we will be using for the project. However, Mr. Cooper Johnson would have more knowledge on this topic than I.
And he's going to testify?
Correct.
Okay. No more question.
All right. Across, so, let me see, I see ya. So we're gonna go through in alpha order if we can, but people raise their hands first. I didn't know everyone had questions, but we already asked that before, so go ahead with your questions.
Now, you, I believe stated that
Give them your name, please.
Can you get closer to your microphone?
Make sure the green light's on.
My name's Linda Bryce, and I just wanted to ask you, I believe you said that the turbines that you were going to put in were safe for the public, but you don't know what model it's going to be, so how do you know, how can you tell that they're all safe for the public?
The models we are considering are safe for the public and widely used in the wind industry.
What are your specifications of safety for the public?
I am not an engineer. I can't speak to specific turbine specifications. However, we do have an engineer, Mr. Dan Kurz, here available to answer your questions.
Thank you.
Okay, Mr. Schwartzman?
George Sportsman, Mr. Herner, how close do you live right now to an industrial wind turbine?
I live in the city of Chicago.
So we're talking, what would you estimate, 30, 40 miles? Hard to say. Okay, you don't live anywhere near a wind turbine right now, correct?
Correct.
Okay. One more question here. Who owns Invenergy, Badger Hollow Wind LLC?
I'm not aware of an entity called Invenergy Badger Hollow Wind.
Or
LLC.
who owns Badger Hollow Wind LLC?
I'm not aware of an entity called Badger Hollow Wind LLC.
Well, that's what I've been hearing all day, Badger Hollow Wind LLC. What company are you working for?
I work at Invenergy LLC.
Okay, thank you. Who owns Invenergy LLC?
I am not aware of the corporate structure of ownership of Invenergy LLC. I cannot speak to the percentages of ownership or shareholders.
It's not owned by a foreign country in Portugal?
I'll object is outside the scope of testimony.
You already said you didn't know, so.
Okay. That's all, Your Honor. Thank you.
And I think, no, I'm not gonna volunteer you if you don't have one. Go ahead, this one.
Good afternoon, Mr. Herner. I'm Amy Hunt, representing the trustees of 435 County Highway E. I have a couple of questions for you, clarifying questions on statements that you made previously in your testimony during your testimony with Wisconsin Policy Monitors Cross on individual hardships. Are you familiar with where our family farm is located within the project area?
I have seen a map of the project area, yes.
And are you familiar with where our family farm, 435 County Highway E, Rui, Wisconsin, is located within that project?
Yes.
Are you familiar with how many wind turbines directly border that property?
I don't believe any turbines are on property lines bordering the property.
Let me clarify that statement. So you don't believe that there are any turbines sited on properties that neighbor our family farm?
There are turbines located on parcels neighboring your family farm.
And how many turbines is that?
I would need to see a map to give you the exact number.
Okay, it's 5. With that, and your previous statement that any turbine has the potential to move 250 feet in any direction, and assuming that you would still be within the limitation, or not limitations, but you would still be within the setback requirements and other. Assuming that a farm that's surrounded by property that's surrounded by 5 turbines that could potentially move 250 feet in any direction, that it's unknown what that impact would then be to our farm.
Objective form, also stipulation.
Okay, I'm gonna allow it. I think, well, let's see what the witness says. I think there's enough in the question for him to get an idea of what that question means and answer. You need some clarification, let the questioner know.
No matter which direction turbines are shifted within that 250 feet radius, they will be compliant with PSC 128.
Okay, so then shifting any of those turbines 250 feet in any direction will not change the potential noise levels or shadow flicker impact to the residents that is currently at 435 County Highway route.
It will, but they will all be any shift will be in compliance with the statutory standards.
So is that the same as saying that any 250 feet shift means that they would be further away from our property lines? Or how would you determine, how can you say today that any movement of 250 feet of any one of those 5 turbines does not change the potential of the noise level and the shadow flicker of our home, of the home residence that's located at 435 County Highway route?
Additional noise and shadow flicker studies will be ran if any turbine shifts are necessary. And that is how we will determine whether or not it is statutorily compliant.
And if you run those additional studies and you find that the movement exceeds the statutory limitations, what happens then?
There are plenty of options. One, shifting to a different location. Two, potential curtailment of the turbines.
And how would since we are non-participating landowners, how would we be notified of those studies and kept abreast of that research?
My understanding is that those studies will be shared with the commission. So you would be able to see through the commission.
No further questions.
So let's, I'll do this off the record. So just so we know, we're asking questions, not to pick on you, Ms. Sant, but, but you did, the way you asked the question about the 5, you said there's 5 turbines. So I think we don't want to have you testify that there's 5. Well, not now anyway. You could testify later that there's 5, but if you could say, if I said there were 5, would there be any reasons for you to disagree with that? And you could say no, and then you can move on. So just in terms of form, but
Thank you.
okay, so back on the record, any other cross? No, redirect?
Thank you. Mr. Herner, if a turbine location is moved up to 250 feet, can you just explain what additional diligence will be performed before construction?
I believe additional geotechnical borings for the new location would be completed, as well as additional noise, shadow flicker, and confirmation that all setbacks are met.
And if it is determined based on those additional analyses that the state regulatory requirements are not met, will the turbine be sited in that location?
If the statutory requirements are not met, the turbine will not be sited in that location.
Do you believe that an adjustment of a turbine location, taking into consideration this additional pre-construction diligence that will be done, will cause undue individual choice?
I do not.
You were asked a question about property rights. Can you confirm that the gained all necessary property rights to construct the project?
Yes.
Is your testimony that the project is in the public interest based on the entirety of the testimony, exhibits, application, and appendices that have been submitted in this docket?
Yes, that is correct.
Same question as for individual hardships. Is your opinion that there will not be undue individual hardships associated with this project based on?
Sorry, is there a question? I'm sorry, I lost it. Is there a question? What's your opinion?
Sorry, same question as to individual hardships. Is your opinion that there will not be undue individual hardships associated with the project based on the entirety of the testimony, exhibits, application, and appendices that have been submitted in this matter?
Yes, that is correct.
Same question as to safety. Is your determination that the project is in the public interest considering safety based on the entirety of the testimony, exhibits, application, and appendices that have been submitted in this matter?
Yes, that is correct.
I have nothing further.
All right, let's go off the record for a second. I think it'd be beneficial if we could get it back on the record when we figure this out. Just where the map of the 435 property is. Because these maps get so confusing in terms of finding a particular location. So we looked at the detailed project area map.
On the detailed project area map, Your Honor, our farm can be seen on page 12.
All right, I'm glad you figured you had the answer right away. So.
So you're, if you center on page 12, Your Honor, the easiest way to locate 435 County Way, Highway 8 Rui is on the upper center of that screen. Oh, if you stop scrolling, because now it's the bottom center, but that right there, that begins our farm. And then all of those series of long straight rows, that's our farm as well. Yes, and then those shorter fields that are directly east of turbine location 5 on there, that is also our land. Before County E borders all of our farm to the east.
Okay, so is there let me just. out the residents that,
If you scroll down, the residence is directly in front of the fields that are contoured, right there, Your Honor. It's to the lower right of your cursor.
of this here. So essentially in the middle. Middle of the page, okay. Let's get on the record. So we just spent some time identifying the the 435 property on the detailed project area map, and we find it on map 4.1.2 page 12. In the middle of the map, essentially. And the residents in question. Yeah, I'd say it's.
Right there, Your Honor, those series of contoured fields, it's right to the east, so it'd be directly west of County E.
Okay, perfect, thanks.
Just to add for the record, to help orient whoever might be reading this transcript. I think that would be south of Bollant, Bollant Road, if I have that correct.
Oh, yes, okay, I see that there, great, thanks. All right, that's it then, you're excused. Third witness for the day.
Thank you, Your Honor. The applicant calls Cooper Johnson.
Your name come up a couple times already, so welcome. You swear or affirm the truth, that you swear or affirm the truth, the whole truth, nothing but the truth.
Yes, sir.
You're right. Go ahead.
Good afternoon, Mr. Johnson. Could you please state your name for the record?
My name is Cooper Johnson.
Where are you employed and in what capacity?
I'm a Director of Renewable Development at Invenergy.
Have you prepared and caused to be filed in this proceeding direct testimony consisting of 14 pages and 1 exhibit, and rebuttal testimony consisting of 9 pages?
Yes,
Do you have any corrections to your testimony?
I do not.
Is the information contained in your testimony true and correct to the best of your knowledge?
Yes, it is.
If I asked you the questions set forth in your testimony today, would your answers be the same?
They would.
Have you had the opportunity to review the sir rebuttal testimony of Commission staff witness Olivia Pullman?
I have.
Does Badger Hollow Wind agree to the condition witness Pullman proposes in her sir rebuttal testimony?
Oh, off the record. Who's playing the video?
I can't see the images that have been put, so I thought I would look.
Oh, is it working? Okay. Okay, oh yeah, just keep the sound off. Yeah, so you have the zoom up.
All right.
That's right. All right. So where did we stop?
Does Badger Hollow Wind agree to the?
Does Badger Hollow Wind agree to the condition that witness Pullman proposes in her sir rebuttal testimony at page 2 regarding micrositing of turbine facilities?
Yes, Badger Hollow Wind agrees with the condition that witness Pullman proposes regarding microsite wind turbine facilities.
Witness Pullman also proposes a condition in her sir rebuttal testimony that would require Badger Hollow Wind to submit its finalized SPCC construction and operating plans prior to construction and commercial operation of the facility. Does Badger Hollow Wind agree to this proposed condition?
Yes, to the extent it's required during construction and operations.
Judge Newmark has revised the decommissioning estimate provided by Mr. Reagan to $285,855 per turbine. Can you please comment on this?
This value is in line with our conservative estimates in the decommissioning plan. It's nominally higher, but not statistically significantly higher, so
no further comments than that.
Mr. Johnson is available for cross-examination.
All right, let's go down our list. Questions from Trice?
Thank you.
I'm sorry, I didn't hear you.
Have none, thank you.
Thank you.
Okay, Jenkins? Metallica? Owen? The state commission for last, Reagan?
Yes, sir.
Okay.
I have to ask the same question I asked the previous gentleman. Tim. What turbine do you plan to use?
We haven't determined what turbine we're gonna use. There's still some factors that are at play for us to make that final determination.
How do you plan to reach the 118 megawatt?
I think-
Without additional turbines?
So I think an important point of clarification is that we're proposing a facility that is up to 118 megawatts, and that may include a mix of turbines. So it's possible that we can achieve 118 megawatts with turbines of a similar size and a mix of those sizes, or that we propose citing less than 118 megawatts as requested in the application.
That's because last night did the math on it, 19 turbines times 6.2 equals 118 megawatts. That's your program. So you might, so somehow it would appear that you've got to use the B162 somewhere.
Object form.
Okay, that's staying, yeah, I think we wanna, I mean, what I'm hearing you wanting to know is if 118 megawatts, is that a set in stone number that you cannot deviate from?
We won't exceed, and we're not requesting to exceed 118 megawatts.
And then in terms of number of turbines, can that vary as well?
That may also vary. If we use a smaller turbine as part of the mix, it is not uncommon to have two different turbine manufacturers in one wind facility.
Okay, and in terms of turbine sites, will those increase or decrease depending on which turbines you end up using in the end?
They may have authorized.
And how, in what way?
There are other turbines that are not 6.2 megawatts in capacity, and there may be sites that we would request increase the number of proposed turbine locations if we use a smaller turbine site.
Okay, so
Turbine capacity.
So you would change. So depending on the choice of turbine, the applicant intends to modify its application by increasing the number of proposed sites.
We have proposed sites as well as alternative locations that we are asking be reviewed under the same criteria, so they are all equally reviewed by the same standard and would be suitable for siting any of the turbine models that we described in the application.
So you'd be using a mix of the proposed sites and possibly adding additional sites that have already been proposed in the application as alternatives.
That's correct.
Does the applicant intend to add any sites that are not currently in the application?
We do not.
That might be the question we're really looking for. Won't exceed 108, so just correct me if I'm wrong here, confirm that this is correct. It's gonna be a maximum of 118 megawatts. Depending on the capacity of the turbines selected, that may increase the number of. To maintain 118 megawatts, and you have a lesser capacity turbine, you may end up increasing the number of sites, but that won't be any site in addition to already identified in the application.
That is correct.
Does that answer your question?
Kind of, because I only see two turbines in document 521329 that are addressed. It's a 3.8 and a 6.2.
Okay.
I've got questions on the 6.2, especially the 3.8 probably being more common, but Or you can answer for both turbines, how much oil, how much synthetic oil does a 6.2 hold in the Nassau? Just synthetic oil.
I'll object as this is outside of the scope of this witness's testimony.
Is there a witness that can answer that?
There will be a witness that can answer questions related to the engineering of the turbines. That's Mr. Kurz.
Okay, so we reserve, just say that name again, what was?
KURZ.
Kurz, okay. Yeah, I'm gonna reserve that for Kurz. Any other questions?
Just one more, what is the decommissioning amount? What is that based on, the 6.2 or the 3.8?
Let me have a look at the decommissioning report to see if we specify in certain manufacturer.
I would say it doesn't, but it sure does.
Okay, well, it's off the record, let's let him check. Back on the record, right?
Back on the record. So in the introduction, we described the project includes the construction of permanent facilities, including 19 Vestas V162 6.2 megawatt wind turbines. So that is the basis for the decommissioning estimate. Which
Why are
will
you
be,
talking about?
Wait, not at the same time, I'm just let him finish.
again, we propose to revisit and revise. We would obviously be revising the decommissioning plan if a different turbine manufacturer was identified or a different Vestas machine was used. And we propose that to be reviewed ongoing through the life of the project.
Are you referring to, appendix D, isn't it?
Oh, hang on, let's go off the record. You mean in the application exhibit itself? Let's check. So I think, so let's get on the record. So I think, Larry Regan, the party is, referencing, appendix D, the decommission plan in the application, and there's two versions. I guess there's an original and a revised. So I think we probably want to know which one we were just referring to. There's a date on there.
There's a date on this. It's October 2nd, 2024.
So that there's to be the revised. No, that's the original.
I'm sorry, Your Honor, that was attachment A in the decommission plan. Decommission is appendix D, but attachment A gives us a cost estimate.
Okay, well, off the record again, so let's look at the January 2025 version, the version that's revised. And there's a appendix A. Yeah. So is that near the back? Just this table, or it doesn't say appendix of it?
Page 12 of the PDF says attachment.
Oh, that's the, okay. Right. So just to be sure, let's get on the record, just to be sure, I'm just gonna ask you, when this, I'm sorry.
Yes.
Looking at the revised appendix D decommissioning plan, does that also reference the Vesta, turbine as being the ones that are in the cost estimate? the decommissioning is.
Is this the revised version on the revised filing on the screen?
Yeah, on the screen. But I,
You scroll down.
oh, down.
There's a cool one here. It says 19 turbines on the cost estimate.
And then
Maybe back at the top, it specifically says Vestas.
Your Honor, if you go to page 4 of the PDF,
yes, okay, I see it's there, all right. The best is. Oh, so then we have a question about appendix A. Attachment A, sorry.
Yeah, just as it says, doesn't it say 19 turbines? But that would have to be the best of 162 that we're talking about.
I think we've established this document deals with the Vestas, that's what the document.
162. Because Vestas makes multiple turbines.
I guess you want to confirm that for us.
We might say it on page 1, it might say rotor diameter, which is the 162 figure.
Yes, it does say that, and
Right,
and that's also the case for attachment A.
that's what it looks like.
Are these figures for the tonnage figures, do they apply to the V-162?
To the best of my knowledge, yes.
My math doesn't come out with this.
I go, I'm having trouble hearing you, I don't know.
My math doesn't come out the same as your math.
Where's the math wrong? Can you show?
I'll give you an example though. On page 1, I don't think this page is numbered, but fiberglass blades recycling. Go down to that line.
It said Hall, did it start with Hall or Hall?
Right below.
Oh,
Right below.
fiberglass blade recycling, okay, I see.
That would be 647 tons. So if there's 19 turbines, and we are using the V-162, and each turbine has 3 blades, and each one weighs 27 tons. That appears to me to be a low number. Would you agree?
I think we're gonna have to refer to an engineer who may have that specification.
Is that a different witness?
That'd be witness photos.
Okay.
I have some other, but no more questions.
Okay, okay. All right, go ahead.
I have a question. Have any of these,
Introduce yourself.
I'm Gina Metallica.
Hello.
Have any of these Vesta 162, 6.2 been built anywhere?
I believe so, but I don't know specifically. I think there are models operating in the field, but none in this project area. Yeah.
I'm aware of one model that is available down in Texas. Are you aware of any others?
I don't have that off the top of my mind.
So there is a chance that they're going to be building these turbines in the driftless region in karst geology that have never been built anywhere else. Is that correct?
I think you said there were some built in Texas.
One,
There's one in Texas.
at a research facility.
objection foundation.
Well, that's in the record as far as I know, but is there? So that's already been established. I think we've already had questions and answers about this topic. Is there anything that you need to particularly verify with this witness about karst geology and the proposed project?
Whether there's any research done of building these larger than anything else that is built in the US in karst geology.
I'm sorry, I'm having trouble hearing you. Whether there's any research?
My apologies. whether there's any research done building these large turbines, the largest to be built in the United States in karst geology.
And I'll object to the extent that this is outside of this witness's testimony. We do have a witness who will testify in depth with regard to the karst features of the site. That's Mr. Patton.
Okay, let's hold off for Patton, and again, this has been already vetted in the written rounds of testimony, so not sure what the value is gonna be for asking these witnesses again on the stand. It's a little tricky here, but I think what I've tried to do by allowing your testimony in and allowing the applicant to rebut that testimony is to have all that information before the commission. To re-ask the same witnesses, the same question is really, it's something that we try to avoid because we've already established the facts from each witness. So if you have any particular question about a witness statement that you'd like to challenge, that's one thing, but just to gather their opinion and have them restated again, we're gonna have to limit that, especially with the time constraints we have in the case. All right, so who's next? Order a bit, are we new? Any questions?
No.
Mr. Schwarzman?
No questions, Your Honor.
Anything from Jenkins?
No, sir.
No. Trustees?
No, Your Honor.
Okay, and WPM. I'm clean, I didn't ask.
Oh, you're okay.
Your Honor, commission staff is.
We have WPM.
Oh, I'm sorry. I thought you said no.
Good afternoon, Mr. Johnson. My name is Eric Olson and I'm here representing Wisconsin Policy Monitor LLC. I have a couple questions for you, okay? First, on page 10 of your direct testimony, at line 16, you stated the project will not create individual hardships. What is your basis for that statement?
I would affirm the cross-examination of my colleague Griffin Herner that we have followed the state citing criteria and that the project is in the public interest and in following this citing criteria will not create individual hardships. And we have brought experts to bear to answer questions in more depth.
Okay, so the basis of your statement is that, to the best of your knowledge and belief as we sit here today, the project will follow all state and I suppose local and federal citing criteria. That's one basis for your opinion, correct?
We will be following the state's citing criteria. We are seeking approval from the state jurisdiction. I want to just clarify that, and then we'll be following the application filing requirements and PSC 128 for citing turbines and facilities.
Okay, let me ask this question in an easier way. One basis for your opinion, which you state at page 10 of your direct at line 16, is that you believe that the project will follow all of the relevant statutory provisions as far as setbacks and levels and other requirements set forth in the statutes. Fair, that's one of your bases, right?
I believe the statutes were developed to promote the public interest, and that's where the citing criteria was developed, so yes.
And another of your bases is the testimony of the other experts who have been hired by Badger Hollow Wind that are going to testify in this document, correct?
Yes.
Okay. So you do not offer your own expertise other than what you have just stated for the proposition that the project will not create individual hardships, fair?
I believe if we follow the law, we will not create any individual hardships with citing of facilities.
So that would be that you agree with me that you do not have any independent personal expert opinion other than the bases that we've already discussed for your proposition stated on page 10, line 16 of your direct, that the project will not create any individual hardships.
I'm not sure I understand the question.
Other than what we've already discussed, do you have any additional bases for your statement at page 10, line 16 of your direct, that the project will not create individual hardships?
I've been developing utility scale renewables projects in Wisconsin for 6 years. I believe that grants me some level of expertise, and I rely on the laws set forth in the state of Wisconsin for siting these facilities. I believe they promote the public good and they will not create individual hardships. And that this project is in the public interest.
Can you tell me any specific basis for that opinion other than the ones that we've already discussed?
Objection, asked and answered.
Sustained.
You state at line 22 of page 10 that the applicant has specifically engaged with certain individuals to address their concerns, including providing compensation via good neighbor agreements, correct?
Correct.
Is there a copy of any of these good neighbor agreements that has been filed as evidence in this proceeding?
I would want to have Herb up there and scroll through it and see if we filed that as an appendix we have in prior proceedings, so. The form at least.
Would it be fair to state that you are familiar with generally what the good neighbor agreements contain?
I'm familiar with the contents of the form of the good neighbor agreement.
Okay, would you agree that the good neighbor agreement that the applicant obtained in this matter contained a provision that would prevent any of the people who had entered into a good neighbor agreement with the applicant from ever litigating against the applicant for nuisance or any other reason?
I'm sorry, whatever, litigating against the applicant for,
Causation of a nuisance or any other reason related to the project?
I'll object foundation. If you need to see the document.
Yeah, this is, so if this is offered in the application, it's never easy to find, so if you guys have, a way to reference that, you can do that.
Are you asking me or Ms. Rolls?
Anyone. The group effort at this point.
Your Honor, the applicant may know better, but I wonder if it's in the materials in appendix ZC in the application exhibit.
Your Honor, these materials, I believe we did submit it, but these appendices are very voluminous, so it might take a bit of time.
I understand. I'm not seeing it, although I've seen in the past from other applications, but that doesn't mean we have one in this case. Yes, I'm going to say unless the WPM has that document available for us, we're gonna move on. I don't.
Right.
Can't spend more time.
Yep. Mr. Johnson, would you agree that the reason that the applicant offered the good neighbor agreements that are referenced in your, testimony is to compensate the people who the applicant entered into those agreements with for negative effects that the project could or would cause to them or their property?
We offer good neighbor agreements at a lot of our properties and a lot of our projects to neighboring properties. It's commonplace in development. Folks can't participate in the project if they don't have land to host facilities, but that doesn't mean that they're not within the project area boundary. It's a consideration for those folks who are nearest to proposed facilities, but can't get a wind easement or a collection easement.
You read that question.
Yeah, go ahead.
Mr. Johnson, would you agree that the reason that the applicant offered the good neighbor agreements that are referenced in your testimony is to compensate the people who the applicant entered into those agreements with for negative effects that the project could or would cause to them or their property?
I'd correct my statement and say no at the beginning of the trailing response.
Just off the record for a second, so I think I did find. It's like a letter, basically, it's like a form letter. Doesn't look like an actual agreement, but maybe it's like the beginning of a notice that there could be an agreement. It's partially redacted. But it's on PDF page 33, and the document is that appendix C.
I believe it's 521445. Yes, the recommended.
Right, that's the redacted version, but it's appendix ZC part 2 of 2. As it's listed in the current application exhibit, so. We need to look at particulars about that. We'll need to go into closed session, but. There is not a lot of it is redacted, but some of it is. Let's just get on the record and identify the good neighbor agreement form letter that's been offered in this case is in the application. Exhibit Z, I'm sorry, appendix ZD. C. Appendix ZD.
CC.
As in cat. Oh, I'm reading the wrong, okay, yeah. Appendix ZC, part 2 of 2, sorry, I'm, yeah. So that at least gives us an idea of what is involved, and if we need to go across, okay, well, if we need to go into closed, I don't know if everyone's, if anyone is allowed to look at the closed session materials yet, but we'd have to go and do that. So let's proceed.
The
Can you pull the microphone a little bit closer?
I think that. Are you the one, Mr. Johnson, who had the most knowledge amongst the witnesses for the applicant is calling about these good neighbor agreements?
Myself and my colleague Brandon Davis will be the ones with the most knowledge of these agreements.
So if the answer to my last question was no, what was the purpose for the applicant offering the agreements?
I'm sorry, offering the,
Good neighbor agreements?
thank you.
I think I did answer that And then I went back to correct and say no in front of it to directly answer your question. I've been talking about us as a matter of practice, offering these to individuals who are near other participating landowners, but don't have land to site turbines or other facilities. We do have these other easements that we bring into the community called good neighborhood participation easements. So that would be the reason.
So if I understand, it's just a fairness consideration.
Objective form that states his testimony.
Overruled.
Fairness, I guess I can't speculate why somebody would join the project in each individual instance or at the outset of a project. But we are offering them as a good faith gesture to those who can participate through our traditional siting easements, which would host actual facilities. So these folks are a couple of acres maybe, or just a 1 acre farmette that's in the project area and adjacent to participating wind leaseholders.
If we, you've stated that you are familiar with the good neighbor agreement, correct?
Yes.
And so are you telling us on the record here today that there is nothing in that good neighbor agreement that would preclude a person who signed a good neighbor agreement from litigating against the applicant for example, nuisance caused by the project, if hypothetically they had such a claim?
I don't think there's anything that precludes litigation on the basis of nuisances. I know that frequently there are setback waivers in these agreements as a participant to the project and receiving compensation. Those are typical in all easement agreements. But I don't think we have this document. I would want to refer to the specific section we're referring to make sure I'm answering this accurately.
I can represent you that I don't believe this document was offered into the record, so. Okay, a couple of questions on the decommissioning. Are you the witness who would be the one to ask questions about the decommissioning plan?
Yes, to the best of my knowledge.
So before we go on, I just wanted to advise you, Attorney Olson, so that if you want to bring a document and ask questions about it, that's one of those documents you needed to email us yesterday. So the fact that you're asking questions about his knowledge about a document that we don't have really does confuse the record. So in the future, that's something you could have brought in and we could have reviewed here today. And I don't know where that line of questions really leaves us at this point, but it would have been useful to have that document and have done it that way. So go ahead. Decommissioning plan.
Yes, the decommissioning plan. Was there a reason that you picked the 10th anniversary of commercial operations as the time to update the decommissioning plan?
Yeah, so I think that speaks to the value proposition of the project itself, which is capital intensive and retains value for a reasonable period of time. 10 years is appropriate.
The cross of Mr. Reagan asked about the mathematics for the quantities in the decommissioning plan. You remember that cross-examination, correct?
He asked some questions and made assertions about properties, yes.
Okay. If it turned out that the quantities in your decommissioning plan were incorrect, you would have to redo that plan with the correct quantities in order for your opinion to be accurate, fair?
Your Honor, I'll object. I think we established during Mr. Reagan's cross-examination that Mr. Kurz can testify as to the numerical values that are cited in Appendix A to the decommissioning plan.
But your question isn't about the map, it's about if the contents of the project changes, then the decommissioning plan ought to be changed.
Then would he agree that his opinion would have to be updated to take those new quantities into account in order for his opinion to be accurate?
That's fair, I think, too.
Okay, so as an example document, I think we had some discussion about final turbine selection. We have to make a basis for the filing. We've made a basis using the Vestas V162 machines on this decommissioning plan. If we used a different turbine type, those would necessarily change. We expect to have to update this plan. We have proposed to continually update this plan. And that's the basis for it, just to make sure at the end of life, we've got funds sufficient to remove the facilities in accordance with what we expect state requirements will be to decommission the project at end of life.
So at the lines 14 through 17 of page 6 of your rebuttal, you state, given the estimated net decommissioning costs are both conservative and offset by salvage value, Badger Hollow Wind does not believe it is reasonable or necessary to establish a decommissioning funding mechanism at this early stage of the project. My question is, when does Badger Hollow Wind believe the decommissioning funding mechanism should be established?
I believe in my rebuttal or in my direct testimony and stated at year 10, that's when it's appropriate to provide surety or a bond or a letter of credit or some mechanism.
Okay, so the applicant is proposing that through the entire 10-year period, the entire first 10-year period of the existence of this project, the public would be unprotected by any type of a decommissioning funding mechanism, true?
I disagree, and again, I think I talked about the value proposition in this project area. It actually has a truly amazing story about the Monfort wind farm. There was a pretty spectacular bankruptcy with Enron, and they are the ones who built that project, and it has subsequently been operating. It's one of the oldest wind farms, if not the oldest in Wisconsin. I think that's a in situ example of the inherent value of a project that has very low fuel costs, doesn't have huge operations and maintenance costs, and doesn't have risks to the public or high impact on the ground there. At year 10, it's appropriate for us to post that bond.
Okay, I would move to strike that as non-responsive.
No, and overall, it's fine.
Okay, so if I understand then, the only protection that the public would have as far as a decommissioning funding mechanism throughout the first 10 years of the project would be the inherent value of the project. True?
Yes, they're inherently very valuable for the first 10 years of life. The risk of abandonment is exceedingly low during that time frame.
Would it be a fair statement that nowhere in your testimony do you discuss what the risk of abandonment within the first 10 years of a project like this one is?
I don't know that I place the odds on abandonment or characterize that risk.
You On page, 3 of your rebuttal, at lines 21 and 22. You state, fiberglass blades will be hauled for recycling at REGEN, Regan Fibers Recycling Plant located in Fairfax, Iowa. Why was that recycling plant selected?
So there are several, this was an assumption that we made, but then I assume it's based on proximity. We're in western Wisconsin, Fairfax, Iowa is not far. There are other recycling facilities for blades elsewhere in the country, but it would be further away. So we would want to keep the cost down and haul those materials to the closest location. That's the assumption under this decommissioning.
Do you know how long Regan Fiber has been in operation?
I am not aware of how long Regen has been in operation.
What sort of vetting, if any, did you do as far as Regen Fibers business model and the likelihood, if you can ascertain it, of that company even being in existence at the time that the blades would be decommissioned or hauled?
Again, we have to make some assumptions. This company exists now. If there are other companies, it's possible that these waste streams will become more like recycling centers will become more available. There may be one that is closer than Regen's and costs could come down for recycling blades, which is why, again, we want to review the decommissioning plan every 5 years. We had to make an assumption at this point in time with this application to review the facts as they stand today during this proceeding.
You've testified that, in your opinion, the likelihood of abandonment of this project within the first 10 years of its life is unlikely, maybe even extremely unlikely. In the unlikely event that this project were abandoned and needed to be decommissioned within the first 10 years of its life, who would be financially responsible?
The project is responsible. I mean, again, like I think that the likelihood is so very low, and there is I'm not aware of other project areas where we've proposed where this has actually occurred, where a bankruptcy occurred and the project was bought and sold twice over and still operates to this day. And it is this community, the Montford Wind Farm. And I would have to rely on that very strong example to point to, a very local example for my contention.
So due to your reliance on the historical experience of the Montford Wind Farm and your opinion that it is unlikely or extremely unlikely that this project, if approved and constructed, would be abandoned within the first 10 years of its life, you did not formulate an opinion as to who would be financially responsible should it have to be decommissioned within those first 10 years.
I'm sorry, should it have to be decommissioned?
Within those first 10 years.
I guess I disagree with the premise that it's based, that its inherent value will make it very attractive for somebody to buy the project out of whatever financial trouble that it's in. And they will get a very safe, good, low-cost project at a great price because for whatever reason it had become insolvent. And there will be buyers for the assets. Consistent with Montford Wind Farm.
Are what size are the turbines at the Montford Wind Farm?
I'm not sure.
As we sit here today, you cannot testify whether the turbines that are going to be used at the Badger Hollow Wind Farm, if approved and constructed, will be
the same or different as the turbines at the Monfort Wind Farm? True.
They will be different.
Okay. Okay, nothing further.
Commission staff.
Thank you. Good afternoon, Mr. Johnson. My name is Evan White. I'm an attorney for commission staff. I just have two questions or topics to explore with you. First of all, I know it was some time ago now, but you were asked on direct whether or not you agreed with a couple of order conditions that were presented by commission staff witness Pullman. Do you recall that?
Yes.
Okay. Specifically, two topics in witness Pullman's serve rebuttal, one related to micrositing, and then the other was related to providing finalized SPCC construction operating plans.
Correct, yes.
Okay. I want to ask you about that latter order condition because you said to the extent it is required, the applicant would have no objection. I just wanted to clarify what it is you mean by that or what your scope of agreement is.
Based on my understanding that there are quantities, volumes, liquid volumes that trigger the requirements for a spill prevention countermeasure and control plan, that and that was the reason for the qualifier, that if we weren't going to be storing quantities, volumes of liquids that would require an SPCC during construction, that I wouldn't want to obligate we create something that is not required.
Okay, give me 1 second.
And if we are meeting or exceeding those thresholds, we would agree to share that. The qualifier is solely based on, I'm not sure if it will be necessary based on what we're storing in this.
In your rebuttal testimony on page 7, lines 5 through 6, you specifically state additionally, a spill prevention countermeasure and control plan will be established.
Yeah, I guess we were not specific with the construction component. I assume it will be necessary for operations based on materials that we'll have to store on site and experience energy, but the construction requirement, I wasn't sure on, which is why I added the qualifier.
Okay, so as you're testifying, your testimony said that that will be established, but now here today, you're saying that there's certain thresholds that would trigger whether or not that's required or not?
That's my understanding. This is something that I would need to confirm or could confirm, and also if it's obvious, we will pledge to provide those control plans.
Okay. So your position on the order condition presented by witness Holman is that to the extent a spill prevention countermeasure and control plan is required, given those thresholds, you would provide it?
Absolutely.
Okay. Moving on to the second topic, you were asked some questions.
I have a great thing about the spill prevention. So just curious on your rebuttal. I think Attorney White had mentioned page 7, the top of the page. Oh, sorry, let's back up a little bit. So page 6, you're responding to witness Brown's. So in relation to your rebuttal, I believe what was being asked by some of the interveners was spill related to the operation of the turbine. So within the
nacelle, is that saying it right?
Yeah.
And your response, or I don't know if you were responding exactly to that, but you stated on your funnel page 7 at the beginning of the page that the turbines contain oils and lubricants within sealed systems. So, and then in that same sentence, you said you would take precautions and measures to guard against potential spills or contamination. So, not the same sentence, hang on, it's the second sentence. But I read that to be taking measures and precautions about leaking of the sealed nacelle. Is that not correct? Is that assumption not correct?
Well, I think we were responding to, questions about decommissioning and contamination at that point. I mean, there's a lot in that, and we were responding to the claim that there would be spills and contamination, and I don't believe that will be the case, and if it were the case, we will, because now we're talking decommissioning, I assume we will have a SPCC plan in place during operations, based on what I believe we'll be storing on site for operations and maintenance. And I do state in here, the construction of it, I extend that, and I think that was more of we don't believe that there's toxicity with regard to the construction, operations, or decommissioning for project generally.
Okay, yeah, I think, okay, so then the measures and precautions aren't, as far as you understand them, aren't directed to leaking of the turbines themselves.
No, this was directly responsive to the decommissioning. The plan would be in place based on my experience and my work on other wind farms in my career, that there would be one in place, and we would have a way to manage that, and a plan in place to ensure that if there was a release, that we would clean it up.
Okay, and just to clarify for me, because now I'm understanding this better, so thank you. The spill prevention countermeasure and control plan, is that only related to decommissioning, or does it relate to storage of lubricants on site during operation?
I believe it's a function of the value and volume of liquid that's stored on site during operations, which is, again, I'm coming from other projects construction experience where we thought we were going to supply this and had pre-construction meetings with the Public Service Commission where we were not sure whether we were going to, and it's not clear to me at this point if the construction of Badger Hollow Wind will necessitate that. But if it did, and we were storing materials on site that would require us to provide that, we would definitely provide that.
All right, thanks. Sorry for the asked and answered there, but I just needed to process that. Go ahead.
And just one follow-up on that point, just to make it clear for the record, and I can't remember if you stated it before or not, but what is that threshold that would trigger, do you know the volume that would determine whether or not an SPCC is required?
You're catching me a little bit out of my swim lane on that particular requirement, but we could follow up with construction management teams, and I think we can get you an answer to that, and then perhaps an answer to all of this, or a yes. We will trigger it, yes, we will supply it, if we find that that is the case.
Sure, do you know where that threshold comes from? I guess maybe that's another way of asking.
I don't know, who sets the standard for this requirement.
Okay.
I'm sorry, who sets the standard?
Right, the standard for that threshold.
Thank you.
Moving on to the second topic then that I wanted to ask you questions about, on Cross, there were some questions about the different turbine technologies. I don't want to necessarily revisit that, but I guess I did have a question from your responses. It sounded like the total number of turbines has not yet been determined. Is that a fair takeaway from your answers?
We have not determined the turbine manufacturer, and we provided a range of those. We are assuming we'll be approved to build up to 118 megawatts. If we have to use a mix of turbines that aren't all the highest capacity turbines that we've proposed in the application, then I think we kind of went through this with alternative locations that we may request approval to site because we would need like these turbine locations plus several for the smaller turbines in the mix of the final design.
So I guess that's where I want to ask some questions for clarity for the record, because I think in the application, all the references are up to 19 turbines. So are you asking that the commission approve the construction of greater than 19 turbines?
I would have to check every reference to the number of turbines and confirm that each one, or that we're talking about up to confirm a mix of turbines that we would be asking for that additional turbine location. The alternative is that we're proposing up to 118 megawatts, so if we had to use less, we had to use lower capacity turbines in a mix or all lower capacity turbines due to availability, that we would request less overall capacity in the project. The goal is to build the highest capacity project. But
And I understand that, I guess, from commission staff's perspective, I'm trying to make clear for the record what it is the applicant is asking the commission to authorize. I know you're stating that you're asking the commission approve either the proposed or alternate sites. However, I think that would be more than 19 turbines if there's a turbine constructed at each one. So what specifically is it that the applicant is asking the commission to approve? Is it total megawatts? Is it the total up to 19 turbines? Just so we're clear on the scope of what this project would.
we are asking for up to 118 megawatts, but we've got the application up here. It says up to 19 turbine point locations, so in that instance, if the mixed math doesn't allow us to get to 118 on 19 locations, then we would not be asking for the flexibility.
Got it.
To site on more than 19 locations.
So it would be a maximum of 19 locations comprised of the primary or alternate sites,
Correct.
but not greater than 19 turbines.
Correct.
Got it. Thank you. That's all I had. Redirect.
Thank you. Mr. Johnson, under any circumstances, will Badger Hollow Wind build turbines on any sites other than those that have been included in the CPCN application as proposed for alternative sites?
No.
If there is any change to the anticipated design of the project that would require use of one of the alternate sites, will Badger Hollow Wind commit to undertake the minor siting adjustment process?
Yes.
You were asked a number of questions by Attorney Olson regarding recycling and the decommissioning plan. In particular, Mr. Olson asked you whether regen will exist when the project is decommissioned. Was regen used in the decommissioning plan as a representative recycling facility?
Yes.
And do you believe that it constitutes a good representative recycling facility, such as one that will be used for the decommissioning of the project?
Yes.
And do you believe that the costs utilized are also representative?
Yes.
Is it your understanding that whoever owns the project at the time of decommissioning will be financially responsible to cover the cost of decommissioning?
Yes.
You were asked a number of questions on the SPCC plan, and I just want to make sure there's clarity for the record. There will be an SPCC plan that will be provided prior to the operation of the project, correct?
Yes.
And if the quantity of what will be stored on the site prior to the construction of the project rises to such a threshold level as set by the EPA, you will commit to, when I say you, I mean Badger Hollow Wind, will commit to provide an SPCC plan in advance of construction. Is that correct?
Yes.
Will there be an SPCC plan in place at the time of decommissioning?
Yes.
I have nothing further.
Thanks very much. You're excused.
Who's next?
Thank you, Your Honor. Dr. Hollowin calls Brandon Davis.
And Aaron, raise your right hand. You swear or affirm to the truth, the whole truth, and nothing but the truth.
I do.
No, go ahead.
Your Honor, please state your name for the record.
My name is Brandon Davis.
Where do you work and what do you do?
I work at Invenergy LLC as a renewable development and senior associate.
Have you caused to be filed, pre-filed testimony in this matter?
I have,
And is your pre-filed testimony, have you filed direct testimony consisting of 10 pages and 3 exhibits?
I have,
And have you filed rebuttal testimony? Have you caused to be filed rebuttal testimony in the amount of 5 pages?
I have,
Do you have any corrections to your testimony?
I do, yes. I would like to correct. I would like to correct, on exhibit 2 to my direct testimony. One of the dates of the local meetings was inaccurate. I would like to correct the March 12th date for the meeting at Linden Township to March 19th, as well as adding in a date,
Hang on, let's go off the record for a second. We're in an exhibit, is that? We did speak that correctly, we're.
Yes, exhibit 2 to my testimony.
You're witnessing this. So that is confidential, the public? Maybe I got these mixed up.
It should be the list of
It's not like this is confidential. That's fine.
You're right, Your Honor, that it contains information that is confidential. The information he's speaking to, however, is not redacted.
Okay. So it's, I see. So we're talking about, so this was filed as an exhibit as well, this time, good name for agreement. It was also an agreement. Okay, so this is an exhibit, is this now changing, so we'll stay off the record, so is this now changing the application filing? Looks like this was filed as part of the application. This exhibit 2.
That's correct, Your Honor.
Okay. You actually don't really, well. Don't really need to have this in as an exhibit, at this point, it's probably too late, but. So we need to, so whatever changes you're making to Davis 2, so let's get on the record. So the witness is proposing changes to exhibit Davis 2, which is also an application filing. So let me just understand, if this is filed confidentially, without releasing any confidential information, can you give me the exact location of the changes you're proposing?
That would be table 14.2B.
And what page?
0.2P.
B as in boy.
Is there the page number at all?
On page 2
No.
of the document.
Okay, so let's all go off the record then. So it's point. What's the number you escaped from?
14.2B.
This table, outreach and meeting. Okay, so the dates on the outreach meetings are incorrect.
The 3/12 dates.
And then it should be what now?
3/19.
I think. And is there any other changes to the exhibit that this document you need to make or session?
Solely in addition, if you're on with the subject, that occurred following the date of our submittal.
Another meeting.
Correct.
So just another line there. No, we wouldn't want to add that in. Well, why don't we'll just take your questions on the record and not disrupt the documents that is filed.
I'll just ask a couple of questions, if I think.
Yeah.
Can I ask a question? Is this
Yeah.
the Davis 2?
2C, I believe.
I'll let you all, so, yeah, this page, if you're on the PDF, it's
page 2 on the PDF.
So. Are we ready?
Well, I'm wondering, well, I'm still looking, I think, I'm trying to figure out. Were there other corrections?
Just these 2 dates. So I can just make the corrections on the record with him through Q&A.
All right. Let's get on the record then. Go ahead.
Mr. Davis, what was the actual date of your meeting that you attended with the town of Linden?
That was on 3/19.
And is there another meeting that occurred subsequent to this?
There was a meeting at the township of Mifflin on the 17th of March of this year.
And is it accurate that you attended both of those meetings?
That is correct.
And other than those 2 corrections, if I asked you the questions set forth in your testimony today, would your answers as set forth in your testimony be the same?
They would.
And is the information contained in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
With that, Mr. Davis is available for cross-examination.
So let me just note that the change to the Linden monthly board meeting from March 12th to 2005 to March 19th, 2005,
Not 2005, though, Your Honor.
2020.
2025. When did we do the last wind farm? 2005.
I don't write 2005
That
anymore.
was blue sky, Greenfield. Those changes were referencing dates that were displayed on Exhibit Davis 2 and also the application document Appendix CC. Page 2 of 2, so part 2 of 2. So we're not going to make changes to those documents, but those should be wrote out. All right, so we have cross, as we go down our list, which I've lost. Who's first on that list? Bryce, any questions? Gotcha. Metallica? No. Renew, clean, I forget clean. Oh, no, no questions. Renew? No questions. Reagan?
Yes, just one question. Has Evergy ever owned a wind farm that they constructed longer than 2 years before they sold it? Or 5 years, could you tell me that?
I would not be able to answer that question as I don't know for certain.
Can I ask another question? Oh, I said,
Oh, you only had one? Oh, yeah, I can look into that. I told everyone to that.
this brings me back to the decommission. So if it is sold to another utility, are they just, is there any surety funds or performance bond or they're under the same timeline as 10 years? They're gonna review it?
Any contracts that Badger Hollow Wind LLC executes are transferred over to the eventual owner of the project. And I would also like to make a clarifying point on what I stated last. Invenergy is a developer, owner, and operator of wind as well as is of wind projects.
So the next purchaser would basically be looking at the same terms of 1.7, 3.1 in the CMPC, the same terms, that the scrap value will offset the decommissioning expense before you even have a chance to review it 10 years.
Objective form. I'm thoroughly confused.
You could provide some, I think you're asking him whether, the assumptions that Invenergy is making will be assumptions that any
The next
owner
yes.
will have to accept, and I'm not sure if you could really answer that question, because it's, you're just having him speculate as to what the new owner would do, but I don't know, I guess to the extent that there's any agreement where the new purchaser is bound to anything that Invenergy
commits to. Is there any, in your experience, is that the case in any of Invenergy's projects?
That is a point of clarification that would then transfer over to the next entity.
Yes.
To my understanding, yes.
And what would those things be that would be binding?
At this time, the agreements, the local operating contracts, as well as other agreements made with local governments and landowners at the time of offtake.
Anything else? No. Did I miss Jenkins? Any questions? Did I have some letter? Schwartzman, any questions?
Yes. This Brandon, Mr. Davis, if a blade breaks off, as we had two of those in the Red Barn, one broke off. One October afternoon about 2 o'clock, beautiful weather, calm. And then another blade broke off about 4.5 months later. Who pays for the blade? Who pays for the cleanup? Who pays for the contaminated soil? That's who's responsible for that?
Of course, I understand that is a concern. Safety is our top priority, and in the event that that unlikely scenario were to occur, the owner of the project would go through their emergency response plan, coordinate cleanup, as well as repairing the place.
You said owner of the plan, who, would that be you, Invenergy, or?
That would be
person
Badger
that you-
Hollow.
Badger Hollow, okay. If you sold this to someone else, another company, who would be responsible then? Would you insist that that new company take that responsibility on, or you would be free of that responsibility?
Typically, we would have an operations and maintenance crew within the project area, and they would be the ones directing the repair as well as cleanup of any eventual blade damage.
So in other words, if you sold this to another company, Invenergy's technicians or engineers would still be in on the job then, helping the new company?
That is a possibility.
What would happen in case of an Excel fire? How would that fire be put out?
The cell fire is a very unlikely scenario. However, in the event that it were to occur, we would follow the emergency response protocol outlined for Badger Hollow Wind Farm LLC, and emergency crews would be notified to go on site and contain or remedy the situation.
Just how far away is the closest fire department that would have equipment to take care of a fire like that? Let's say we're in Montford or we're in Livingston. Which fire department, which closest fire department that would have something like that to get up there and take care of that fire?
Clifton, Livingston, Montford, Cobb Fire Departments, these putting out or containing fires do not require specific equipment. And we will be working with the local emergency services during trainings to help them best prepare for any fires. And I would also like to point out that they have been operating within the project area of the Red Barn project as well as Montford, which has been there for over 20 years.
Yeah, well, the Montford wind turbines are going to be about, well, the new Badger Hollow turbines will be about 3 times the size of the Montford. They're different critter, different ballgame. So you're telling me that Livingston and Montford have equipment that can reach, let's say, the hub height of what's that, about 390 some feet? They have equipment that can go up almost 400 feet, put out a fire?
In the event of fire, they would have equipment on hand, but would not necessarily climb the tower.
So how are they gonna put out the fire then? Do they have a derrick or a crane that can reach that high? That you're aware of?
Not that I am aware of. In the event that were to occur, the emergency team would create would work on the ground with local law enforcement to contain the fire.
Sounds a little spooky to me, I don't know. End of questions.
Just wanted to see if you could clarify, when you say contain the fire, what do you mean by that?
Observe and ensure that no additional damages, occurred.
So to just let it burn out, is that another point?
To my knowledge, yes.
Okay. I know. This might be in the application, so I apologize, but does the applicant have any plans to, equip local fire departments with any additional equipment that you can use to, address emergencies at the project site?
I believe that our lead engineer would be able to speak a little more to this, but I would add that, we do not expect local fire departments to need any additional type of any additional equipment.
Who did I ask? Yes.
Good afternoon, Mr. Davis, Amy Hunt, representing the trustees of 435 County Highway E3 this afternoon. We're gonna start with, on your direct testimony, page 2. Line 11, at the end of that sentence, part of your description of your involvement with the Badger Hollow Wind project was that you assisted with the preparation of the CPCN application. Did that include creation of the maps and or reviewing the maps that were submitted with the application on 10/16 of 2024?
I did assist in reviewing those.
Okay, Your Honor, can you please bring back up PSC 521309, the detailed project area map, specifically page 12?
That's off the record. Here's the text down here. So we're at page 12. This is what where you need to see.
Correct.
Should I zoom in more or zoom out?
Yes, please, if you could scroll to the bottom, actually to the map legend.
Oh, all right, let's get back on the record. So we have the detailed map, page 12 on the screen. Go ahead.
Yes, so then, Mr. Davis, on page 9 of your direct, beginning at line 8, it states that at the time of the application's preparation and submission, Badger Hollow Wind was engaged in good faith negotiations to renew a wind energy easement that expired on August 14th, 2024, with the landowner regarding the siting of alternate turbine. Can you please state the physical address associated with that wind energy easement agreement that you were trying to renegotiate?
I believe that was 435 County Road E and Rui. But I may be mistaken. I would have to look at the agreement, so.
Okay, so then if we refer to the map that's on the screen, page 12, the legend, the households are specifically color coded with participating landowners' homes showing as a turquoise blue, I would call that, and a non-participating resident as a white home. Is that correct?
That is.
Okay, so then, Your Honor, if you scroll up and you focus in on the resident that is associated with 435 County Highway E Rui. Mr. Davis, can you please tell me what color the house is that's associated with that address?
That would be white.
Can you please then explain why an application was submitted showing that our family farm was both participating and non-participating landowners in that location? Turbine number 22, if you scroll up, can also be seen on this map.
At the time of filing this application, we were continuing negotiations on an agreement and had eventually believed we would be able to execute. However, over time, we learned that that was not the case and have since removed the parcels from the project.
Okay, let me rephrase that question. I think need some clarification. What I was asking is that this document was created for the application and filed on October 16th. In your direct testimony, you're stating that alternative turbine location number 22 was included in the project because yourself and Badger Hollow Wind Farm LLC believed that the good faith negotiations that you believed to have been involved in gave the rights to include alternative turbine number 22 in the application. But yet in that same application document, you're showing a farm that is both having a turbine, but yet recorded as a non-participating landowner. What I'm looking to understand is how can the same property be both?
At the time of filing this application, we had an expired agreement with 435. We were attempting to execute a new agreement with that landowner to bring them back to participation status. It does appear that this map states that it was a participating landowner when
Is it fair to say that this map actually said that that the land associated with 435 County Highway E was both participating and non-participating, causing a lot of confusion?
the agreement was currently unparticipating at the time, working on executing to become participating.
My question is referring to the integrity of the information on the map that is currently being displayed on the screen, page 12. Page 12 shows both a wind turbine and a residence that are both associated with the same physical property address. But the residence is showing as a non-participating landowner. Do you agree that that is extremely confusing?
Yes.
Thank you. I don't have any chance to.
WPM, any questions?
Yes, good afternoon, Mr. Davis. My name is Eric Olson. I'm here with Wisconsin Policy Monitor LLC. And I have a couple questions for you. Is that okay? Of course. Thank you. First of all, I see in reviewing your testimony that you were one of, or maybe the primary person responsible for doing the public outreach in this project, I guess we call it, correct?
I was one of them, that's correct.
What was the public throughout the course of the meetings and the mailings? What was the public told about how the size of the turbines that are proposed to be used at Badger Hollow Wind compared to the size of other turbines in existence in the state of Wisconsin, if any?
We continue to be transparent with the local governments and municipalities about the possible size of the largest turbine model. And as soon as we were able to, we relayed that information over to municipalities and landowners.
What if anything, throughout the course of the outreach that you discussed in your testimony, did you tell people about how the largest potential size of the turbines at issue in this matter would compare, for example, to the turbines in Montfort?
That it's possible they may be larger.
Okay. how much larger might the turbines in this project possibly be than the turbines in Montford?
For specific engineering details, I would have to direct you over to our lead engineer.
Well, okay, and I understand that you may not be able to give the specifics, but if, when, you know, if it occurred and when it occurred that members of the public asked that very same question throughout the course of your public outreach, would you give them a ballpark answer to help understand how the scale of the turbines at issue in this project compared to the nearby turbines in Montford?
I would.
And what would you tell them?
I would state what is in our application, the max tip height.
Okay. And what would that be?
That would be up to 656 feet.
And what was the highest tip height at the turbines in Montford, if you know?
I do not recall.
What would you tell people when they would ask if they were at max?
I believe they are close to 300 to 350.
Is it fair to say that if constructed with 656-foot tall turbines, the Badger Hollow Wind Farm LLC project at issue in this matter would be the largest wind turbines in the state of Wisconsin in terms of height?
At this time, we are constructing one of the larger turbine models in the state of Wisconsin. However, there are similar turbine models all throughout the country as well as the world.
Are you, I noticed that in your exhibit Davis 2, which has both I'll refer to Davis 2P because that's the one that I had access to. You do not have a copy of the good neighbor agreement, correct?
Of the full agreement, that is correct. My knowledge.
Okay. Would you agree to supplement your testimony with a copy of the good neighbor agreement?
I believe that we have. I believe that we have supplemented with their agreements as well and to understand why. Or, we've been working with the local municipalities as well as local landowners to execute these agreements, which are largely confidential basis. If requested by the commission, we would be willing to send along a form agreement.
So the page number 7, lines 16 through 17 of your direct testimony states Badger Hollow Wind recognizes the importance of community outreach and information sharing. Would you agree that it would be consistent with the principle of information sharing to provide the commission and the community with a copy of the good neighbor agreement that you're offering to landowners, albeit with whatever amounts may be paid redacted?
I would not, as these are confidential in nature, to be executed with the landowner themselves. If it is requested, then we would.
If we look at page 8 of your testimony and on to page 9 of your direct testimony. Starting at line 20, you state. The question is stated, has Badger Hollow Wind done any outreach to neighbors who are not anticipated to host wind generating facilities? And at line 22, you answer, yes, Badger Hollow Wind has offered good neighbor agreements to all non-participating residential property owners identified as potentially being over statutory noise and shadow flicker limit thresholds, as well as answered questions and provided information to any neighbor who inquires. Would you agree that property owners who are affected with noise and or shadow flicker over the statutory thresholds could experience negative consequences to their health and or psychological and or mental well-being as a result of those conditions?
Your Honor, I'll object. This is outside the scope of this witness's testimony. Again, we do have a medical expert who will be providing testimony.
I agree.
What was the rationale, if you know, for offering good neighbor agreements to all non-participating residential property owners identified as potentially being over statutory noise and shadow flicker limit too fast thresholds?
I'm sorry, I missed the end of that.
Yeah. Let me re-ask the question. I think it was too fast.
And just so you know, I sustain your objection, not overruled. It's not overruled.
I understand.
Okay, yeah.
It was.
I did.
If you know, what was the applicant's rationale for offering good neighbor agreements to non-participating residential property owners identified as potentially being over statutory noise and shadow flicker limit threshold?
We are doing so in alliance with PFD 128, and I believe that my colleagues Cooper Johnson and Clifton Herner have responded to that question.
Throughout the applicant's public outreach efforts that you were involved in, can you tell us about any time that the applicant shared with the public that peer-reviewed studies have found that in some instances, wind turbine facilities can cause annoyance to the public?
Production Foundation also said the scope of this testimony.
So let's just have that question read back. You're talking about what they read back the thing also.
Questions about the applicant's public outreach efforts that you were involved in. Can you tell us about any time that the applicant shared with the public that peer-reviewed studies have found that in some instances, wind turbine facilities can cause
That's that's fine.
annoyance?
It's yeah, I'm gonna overrule the objection.
I can't, I don't recall a specific instance offhand of that occurring.
We know that there, from the docket in this case, that there are people who believe that wind turbines can cause negative health or mental well-being outcomes for people, and others who dispute that. What I'm trying to ask is, throughout the applicant's outreach to the public, did the applicant share a full spectrum of the viewpoints on wind turbines, or was the outreach essentially along the lines of what's contained in Exhibit Davis 2P?
We've had shared some studies such as a wind turbine health paper from Dr. Ellen Bogan and Dr. Mike Hinkard. If you have specific questions regarding to annoyance or other health impacts, I would have to direct you over with them.
And I'm not asking about whether or not these health impacts exist or, and I understand that those other witnesses are the ones who are going to talk to that. I'm just asking, did the applicant share with the public the viewpoints of detractors of wind turbines who believe that they do pose health risks? Or was what the applicant shared with the public along the lines of the examples that you gave in the exhibit Davis 2D?
Objection needs to be answered.
Sustained. Okay. As we sit here today, do you believe that the applicant has acquired all of the property rights that it needs to construct the project?
We have acquired property rights to construct our primary. Correct.
Oh, so would you agree that as we sit here today, and just to help you, on page 9 of your direct, at lines 14 through 16, you state Badger Hollow Wind is working with all authorities having jurisdiction to obtain public rights of way permits to ensure that collector circuits do not cross onto a non-participating landowner's property, and that collection is limited to participating landowners' property and designated limited public rights of way. Is that still accurate, or have you now obtained all the land rights that you need? And by you, I mean Badger Hollow Wind.
By land rights, I was referring to agreements, so when collection, good neighbor agreements. We have not to date acquired any right of way permits, we will be seeking them.
Okay. Are you the person who is going to be tasked with seeking the necessary right of way permits to construct the project as designed?
Myself as well as council.
Okay. And as we sit here today, would it be fair to say that you're optimistic that that will be feasible to accomplish, but you're not certain, as they have not been obtained yet? Fair?
Objection calls for speculation.
What's this thing?
That's all I have. Thank you.
So other cross. Commission staff?
It would be cross, Your Honor, but just one point of clarification. There was some questions about a template good neighbor agreement. That is will be in the record. It's response to staff data request 1.1. So for the interest of clarifying the record, there was one provided in response to staff data request 1.1.
Okay, so. We haven't really gotten to this point yet, but so staff does file the data request exhibit, so we'll be expecting an updated version with that link attached.
It's in there.
Oh, it is already in there. Oh, I thought you said we were expecting. Okay, sorry.
Well, I guess it hasn't been received into evidence yet is what I meant, so.
Oh, well, everything on the list is in evidence.
So it is in the data request response exhibit, the response to data request 1.1.
Oh, sorry, simple statement became more complicated. And that's for you. So I did have a couple of clarifying questions based on, I think what we've just heard.
I do have some redirect as well.
Probably want me to ask first though, and then you.
Can I just make one point of clarification along the line?
Oh, yeah, go ahead.
With regard to the data request responses, I also just wanted to point out that in response to commission staff, data request PSC Watson 3, we did respond with regard to Ms. Hunt's concerns as being a participating or non-participating landowner, as well as addressing the change to the project layout associated with removal of turbine 22, which was an alternate site. And that is again in response to commission data request PSC Watson 3.
So, in your questioning with Attorney Olson, it was pointed out to me, I've probably seen it before, but it became clearer this time. The bottom of page
8 of your direct.
8.
8, yeah. And it relates to the good neighbor agreements, and that Badger Hollow Wind has offered good neighbor agreements to all non-participating residential property owners identified as potentially being over statutory noise and shadow footprint limit thresholds. So I guess I'm a little confused. Were you here for the prior testimony of applicant witnesses today?
I was.
So I remember hearing them saying that there were no one would be, that the project was designed and no one would be, over the limits from PSC 128.
They would not be.
Okay, so were there any property owners identified as potentially being over the limits?
In the event that they are, then we will either have to curtail turbines, implement visual buffers, or take other measures, such as.
So they won't be in terms of operations, but there currently are owners identified that are potentially over the limits.
As an operation, there will not be, but.
Who are the landowners that are potentially over the limits as you stated?
There, we have offered good neighbor agreements to 30 different individuals. We have currently executed, I believe the number is 8, good neighbor agreements. And those would be those individuals.
So those 30 property owners, is that the total number of residential property owners that you've identified as potentially being over the statutory limit?
They may not be exactly over, but close to.
Close, okay. Can you provide us a list of those?
I can.
So let's mark that Davis 4. And we'll just have that filed 3 working days after the last date file. Yeah, I'm gonna require being filed as a revised, as an exhibit that will come in after the hearing. I guess. Or free to ask questions about you people though. Right, sorry, and then in terms of the property rights issue that was raised, in your questions with Attorney Olson, I guess you guys were using particular language. Your answer dealt with that property rights were secured to build the project as designed. Is that what you recall?
That's right.
So it'd be the proposed project of the 19 sites.
Correct.
And then we heard in previous testimony today that there, and it's been in the record, everyone should have known this, that there's alternate sites and that the turbines change size, will be using different site locations, potentially adding site locations or shifting site locations. So is your answer different in terms of changing the project design? Do you need to then seek new set of property rights to facilitate the construction of the project?
In the event that we're going to be utilizing alternate turbine locations, then we would need additional leases, which we are currently working on.
Okay, and it would also be private right, public right of ways and the other elements you need to secure property to construct.
Solely agreements.
Just property right, just site agreements.
Correct.
I think that's all I had. Go ahead.
Thank you. Mr. Davis, you were asked what commitments potential purchasers of the projects will have to comply with if the project is ultimately sold. Is it your understanding that any potential purchaser of the Badger Hollow Wind project will be obligated to comply with any conditions to a CPCN that is issued by the commission?
That is correct.
Is it your understanding, you were asking questions about nacelle fires?
I'm sorry, what was that? What fire?
Nacelle, NACL.
Okay. Thank you.
Is it your understanding that in the event of a nacelle fire, local safety officials will let the nacelle burn and will contain the fire?
That is correct.
I'm sorry, who said that?
I said that objection.
I'm sorry?
Objection.
Oh,
I can rephrase.
Go ahead.
What is your understanding of how the local fire safety officials will address an cell fire?
That they will immediately respond and work to contain.
You were asked a number of questions by intervener Hunch related to her firm's participation in the project. Just to be very clear, at the time that the application was submitted, did Badger Hollow Wind in good faith believe it was negotiating with Ms. Hunt and her family with regard to their property rights?
We were.
Are you aware that participating landowner agreements are often negotiated on a parcel by parcel basis?
Yes.
So is it your understanding that it wouldn't be necessarily unusual to have a landowner who has both a participating property and non-participating property?
That's correct.
You were asked a number of questions about whether you provided the public with any information indicating that the project could potentially cause negative health impacts. Mr. Davis, are you aware of any peer-reviewed scientific research that supports a causal relationship between wind projects and negative health impacts?
Leading and foundation.
Yeah, well, that's the same.
Your Honor, Mr. Davis was asked questions about whether he provided any such information. I'm trying to get an understanding of whether he believes any information exists.
He said he couldn't recall, as far as I know. I don't think we need to get any more clarification on that.
You were asked a number of questions about shadow flicker and noise requirements. I want to be very clear, if there are landowners in the project area whose property will be over regulatory limits for noise or shadow flicker, will their properties be subjected to noise or shadow flicker in excess of regulatory limits at the time of the operation of this project?
They will.
Overall.
Can you clarify the basis for your certainty as to that answer?
Shadow flicker and noise are both easily predicted and mitigated. We do have some resident experts with us here today showing blame for shadow flicker as well as vector anchored for noise. But in the event that the modeled amounts were to exceed statutory limits, then we would implement curtailment, vegetative buffers, turbine shifting, or other measures.
I have nothing further.
Yeah. Right, thanks for your time.
Your Honor, can we take a short break before our next?
Let's go off the record. What do we have for witnesses? So blank is one.
We've got, we've completed 3 witnesses, 3 of our witnesses. At this point, we have 9 witnesses left.
Yeah. Yeah, I understand that. All right, 5 minutes. So I'll be back at 3:05.
finally got. I would be able to pull.
Nice.
First of all, there's nothing there.
We used to have, you probably remember that, we had all the applications printed out and the whole building got a shelf. That was
I moved over there a handful of times.
Just
I can start.
line the shelf. Yeah. Right. Oh, no, we still have it.
Oh, yeah. Yeah.
Fast. All right, well, no time to waste here. Yeah, everybody, getting stalled. Well, why don't we get our next witness on the bench anyway? Yeah, it's standard. All right, swear you in, raise your right hand, sir. Or first, let's do.
Thank you. Please state your name for the record.
Jamie Wilson,
Where are you employed and in what capacity?
I'm employed at Energy. I am a director on the environmental compliance strategy.
Ms. Wilson, have you prepared and caused to be filed in this proceeding direct testimony consisting of 29 pages and one exhibit?
Yes, I have.
And have you prepared and caused to be filed in this proceeding rebuttal testimony consisting of 11 pages?
Yes, I have.
Do you have any corrections to your testimony?
No, I do not.
Is the information contained in your testimony and exhibits true and correct to the best of your knowledge?
Yes, it is.
And if I asked you the same questions set forth in your testimony today, would your answers be the same?
They would.
With that, Ms. Wilson is available for cross-examination.
All right. Didn't have anyone listed here with questions, raise your hand. No one with questions? Reagan? Well, Larry, did you have a question? No. Go ahead, George. No,
Sure. Ms. Wilson,
Can you bring the microphone closer?
Ms. Wilson, what's the closest wind turbine to your home?
I don't know the answer to that.
50 miles away, would you say, at least?
At least.
At least, thank you.
All right, other pros? No, all right. Next.
Yes, thank you. Our next witness will be Dave Loomis.
Okay, I guess it's in 3D. You swear or affirm, tell the truth, the whole truth, not the truth? I do, without, go ahead.
Please state your name for the record.
David Loomis, LOOMIS.
Where are you employed and in what capacity?
I am president of Strategic Economic Research LLC.
Have you prepared and caused to be filed in this proceeding direct testimony consisting of 8 pages and one exhibit?
Yes.
Do you have any corrections to your testimony or exhibit?
No.
Is the information contained within your testimony and exhibit true and correct to the best of your knowledge?
Yes.
And if I asked you the questions set forth in your testimony today, would your answers be the same?
Yes.
Mr. Loomis is available for explanation.
Questions with Loomis? None?
Go ahead. I have.
Oh, okay, go, everyone just chime in, go ahead,
Yeah. Mr. Loomis, what is your relationship with Invenergy?
I've been hired by Invenergy to do economic impact studies for a number of their wind, solar, and transmission projects.
And Mr. Loomis, how far are you from a wind turbine? How far is your home from a wind turbine?
I live in McLean County, Illinois, that we had,
Don't talk at the same time.
we, and so I live fairly close to a number of different, wind farms.
Okay, and how close? I mean, sometimes I ask people that and close for them is 10 miles away. So what help could you give me? You know, you don't have to give me within feet, but miles roughly. 5 miles?
I can see, wind turbines from, I'm not sure that I can see it from my backyard, there, but, in driving around town, like, they are in my beach.
Okay, so from home, maybe you can see them, maybe 10 miles then. Something. Okay. Sounds good.
Just state your answer.
Yes, approximately.
Okay, thank you.
All right. And who else? Have we begun?
Okay, so, hello.
So, yeah, just introduce yourself.
Yes, good afternoon, sir, wait. Good afternoon, sir. All right, my name is Eric Olson, and I'm here representing Wisconsin Policy Monitor LLC. Is it okay if I ask you a few questions?
Yes.
Okay. You state in your testimony that you have published peer-reviewed academic articles on the economic impacts of wind and solar energy projects, and that is at lines 5 through 7 of your direct, page 3. Is that true?
Yes.
Do you consider yourself to be familiar with the body of published and peer-reviewed literature on and relating to the economic impact of wind and solar energy projects?
Yes.
Are you familiar with the term annoyance as it is used in relation to potential effects experienced from the construction of wind turbines? Or for the operation, I really should say, not from the construction, but from the ongoing operation of wind turbines?
I'm familiar with that.
Okay. Are you familiar with the article that was filed in this docket as Wisconsin WPM Brown 12, which was the Vermont Department of Health Wind Turbine Noise and Human Health, a review of the scientific literature dated May 2017?
No.
Okay. Would you agree that the use of the term annoyance in relation to the phenomenon that is caused by wind turbines indicates a subjective psychological condition that may result in anger, disappointment, dissatisfaction, withdrawal, helplessness, depression, anxiety, distraction, agitation, or exhaustion?
Your Honor, objection, this is outside the scope of Mr. Loomis's testimony. Sustained.
Okay. How do you understand the term annoyance in relation to a condition that may be caused by the operation of wind turbine facilities?
Same objection, Your Honor.
Any response?
I thought you just testified that he was familiar with the term. So I would think it would be fair game to ask him what he believes it means.
Mr. Loomis is an economic expert, he's not an expert on health impacts or annoyance.
So it's what I propose to do is a very simple line of questioning to establish what his understanding of the phenomenon of annoyance is, and then ask him how he calculated the economic impact of that phenomenon, if he did at all.
Okay, overruled.
How do you, so, well, I'll ask my question again. You stated a moment ago that you were familiar with the term annoyance as it's used in relation to a condition that may be caused by the operation of wind turbine facilities. How do you understand that term? What does it mean to you in your professional usage?
I know it's a technical term, but it's really outside the scope of what I deal with to define it.
Okay. Did you make any estimate of the economic or potential economic impact of annoyance that could be caused by this project were permitted and constructed?
I don't know of any annoyance related to this project, so therefore I did not measure it.
Oh, and fair to say you did not estimate the financial impact of any potential negative health outcomes that could be caused by this project. Or
My report contains no such estimations.
okay, thank you. Throughout your professional career, which looks very impressive, including if we look at page 1 of your direct testimony, you're professor emeritus of economics at Illinois State University, correct?
Correct. Okay, just off the record for a second. To the extent we have already have in the record background of the witness, let's not review it now, just for sake of time. So, yeah, thanks, appreciate that. Go ahead, hang on.
Oh, go ahead.
Okay, get back on the record, thanks.
Did you ever, in your teaching duties, teach on the potential, on the economics of potential health impacts of renewable energy projects?
I taught a course on the economics of energy, and included in that was a section on wind energy, but I don't believe we covered anything on health impacts.
Would you agree that to fully evaluate the economic impact of a project like the Badger Hollow Wind Farm LLC, it would be important to evaluate the economics of health impacts that could be caused by the project?
When I do economic impact analysis, I limit the scope really to the jobs, earnings, and output, as well as the tax benefit. I recognize that there are other benefits and potential costs that would be associated with a project, but that is not something that I typically study.
I believe on page 5, lines 12 through 17, you talk about the job creation that could be caused by the that you estimate will be caused by this project, correct?
Yeah, those are jobs that are created or supported.
Okay. Will any jobs be lost as the result of this project should it be constructed?
There will be a small de minimis impact to agriculture in land that was taken out of production. That would be typically per turbine 1 acre of land. And so they did not measure that because it was too small to really have an impact.
Would it be fair to say that it is unlikely, should this project be built, that any new homes will be built within the setback requirements of the wind turbines?
Within the setback areas? Probably.
So did you evaluate whether or not over the 30 to possibly as much as 60-year lifespan of this project, jobs, local jobs will be lost in the home building community?
I did not measure that nor consider that myself.
In your study, did you evaluate the financial impact of the lost potential to sell land for housing purposes within the setbacks of the proposed wind turbines?
I'm not aware of any such instance, so I did not measure it.
Would you agree that over, are you familiar with housing trends in the locale of the proposed project?
So in my report on page 9 and following, I do an analysis of the economic and demographic background with a roughly 10 to 12 year trend of various aspects in Grant County. That includes employment, unemployment, population, median household income, gross domestic product, as well as number of farm land and farmland. And then I do similar analysis for on page 13 for Iowa County. So I do not look specifically at housing and housing values. I believe there's another expert that will look at property values.
When this one was just give us, do you know what appendix that is on the application of it?
I think it's exhibit 2. And I have the reference number.
Let's go off the record.
I think it's CA, Your Honor.
Yes.
Okay. All right, so back on the record, so when this was referring, the document that's in the application exhibit labeled appendix ZA, economic impact study. Oh, thanks.
And I believe you had, sir, I believe you had discussed pages 8 and 9 was where those, where that information is.
It really starts on page 9 and goes through page 12.
Would you agree that when it comes to the number of jobs at issue, the question of whether jobs will be, well, let's do it by county. The question of whether long-term local jobs will be created or lost in Iowa County due to this project is an open question.
I did estimate that in my study and referenced it in my testimony.
Right, I believe you estimated at line 16 of your direct on page 5 that over 3.5 new local long-term jobs for Iowa County would occur during operations, correct?
That's correct.
Okay. We know from your previous testimony, however, that it's unlikely that any residential development will occur at the very least within the setback radius of each of the 19 turbines, correct?
Right.
Okay, and you didn't do a calculation of how many, if any, jobs will be lost as a result of that essential freeze on development, true?
Objection form.
Overall.
There are many such developments that could be speculated of what could happen over the course of 30, 40 years. And I did not take into account any of those.
Would that answer be the same for Grant County?
Yes.
When you estimated the long-term outputs for the counties and for the state during the operation of the project, what went into that number?
What's the outputs that you're referring to?
On Loomis, direct Loomis, pages 6 and 7, starting with line 13 on page 6, there's an estimate of gross domestic product increase. I suppose that's going to be attributed to the project. And I was just wondering, let's just focus on line 3 of page 7 of your direct, where you state that over 1.5 million in new long-term output for Grant County annually during operations. What goes into that $1.5 million number?
Yeah, so economic impact is a measure of, like, as you said, gross domestic product. Is looking at the value of goods and services in the economy. It's the broadest measure that we usually look at in terms of economic activity. And whereas the earnings only are associated with jobs, economic output has a broader look. It would include the utility aid formula, so that was replacement for property taxes. It would take into account the landowner payments that would come from the project. So it's the as well as the earnings. So it is the most comprehensive measure of economic activity.
Okay, so it sounds like it's largely made up of 3 things. The monies paid from the operator or the applicant to local government in lieu and state, and in this case, local government in lieu of property taxes. The payments to the property owners and the payments from employment, right?
Yeah, it's careful to look at that employment because it includes not only the employees. That would be like the wind turbine technicians, what we think of as direct employees. But would also be employment associated with the spending that Badger Hollow Wind would bring to the local community, and therefore counting the employment in those industries in which they're spending money.
And so then, Iowa County on lines 5 and 6 of your direct testimony of lines 5 and 6 of page 7, you state that you estimate over 479,000 in new long-term output for Iowa County during operations and 3.2 million in new long-term output for the state of Wisconsin annually during operations. Would it be fair to say that those numbers are gross numbers, not net numbers, taking into account any loss that might occur from other activities that may not happen because of the project?
Yeah, I'm not aware of any other activities that wouldn't happen because of the project, so therefore I couldn't measure them, and I haven't taken those into account.
Okay, as an example, if one, let's assume in year 1 of the project, hypothetically, that one $479,000 home was not built in Iowa County due to the infeasibility of building a house within setbacks, then it would essentially be a wash, right?
Objection calls for speculation.
Sustained.
Okay, no further questions, thank you.
Yes.
Hi, I'm Linda Grice. Can I ask?
Off the record for a second. Get your close to the mic. Yeah, and introduce yourself. You were on the right track there.
Hi, I'm Linda Grice. I just had one question. Do you agree that you can't really have an economic impact statement without including all the subtractions from the economy as well as additions to the economy?
I think what you're referring to is a net economic impact as opposed to a gross economic impact, which was previously distinguished with that. And I just say again, reiterate that you'd have to have something to net out, and I was not aware of any alternatives that were proposed for this area.
Okay, so would you classify your economic impact statement then as a gross economic impact statement?
It would be both gross and net because I didn't have anything to subtract out as an alternative.
Did you look for anything that might be affected? Like, I'm thinking of travel. We have a lot of tourism in our county. I know I have people that are not really interested in seeing turbines. What about if land values decrease, tax revenue will decrease also? You know,
Your Honor, I'm going to object to form at this point. You have a property valuation witness who will also testify.
Right, okay, so with respect to the property values, that's a different witness, but, so again, I just wanted to instruct you that when you're asking questions, not to enter facts into the record, so don't give them your assumptions as true. But you can ask them whether they considered these things that, as possible subtraction items. And see what the witness might say. Okay. So right now, there's no question pending. Did you want to ask another or restate what you?
They asked before.
I just, how would you then classify your economic impact statement? Because it's not considering everything. How would you classify it or identify it? As, would you consider it then a gross impact statement, gross income statement?
Objection asked and answered.
Yeah, he already asked that. So he said it was both gross and net. But he had nothing to net out, that he didn't see the thing that the negative attributes to net out of the report. So that in itself is the answer. I don't know if there's anything else, any other way to ask that to get a different answer.
So if you have an economic impact statement and you don't include both the positives, all the positives and all the negatives, is that an accurate economic impact statement?
For an economic impact analysis, there are things that can't be taken into account and quantified for this. So with that qualification, yes, you can do an economic impact analysis.
Did you note on your analysis then that there might be things that you didn't consider?
I believe in our methodology, we made it clear what we were measuring and how we were measuring it. Not sure that I have a statement that specifically says that these are the things that we're not measuring, but by going through our methodology, I think we'll make it clear what we are trying to focus on and measure.
And could you point that out?
It looks like section 4, page 18.
Yeah, I was just gonna point to the executive summary, says the basis of this analysis is to study the direct, indirect, and induced impacts on job creation, wages, and total economic output. And then on page 18 of our analysis, we go through the methodology of how we quantify that. And I think it's pretty clear from those direct, indirect, and induced impacts what we are trying to measure.
Okay, so you said you had made a total economic output. But do you think that that is the overall an economic report, or is that the totality of an economic report?
Objection asked and answered.
If it's just the output, is that a reflection on the true economic benefits or losses?
I think we've heard the answer for the extent that the study states what the methodology is, and the witness has been clear as to what the limitations were in the analysis. We have an answer on that. So there may be things that are not in here that you'd like to see, but they're just not part of it.
Thank you.
No questions? Any other cross redirects?
Thank you, Your Honor. Mr. Loomis, you were asking questions about the nature of the project and potential project area, potential uses for the project area. Would you categorize the project area currently as agricultural?
Yes.
Did you account in your analysis for the fact that participating landowners will receive income from Badger Hollow Wind?
That was included in the output measure.
What impact did you conclude that those payments would have?
So that was included in the economic output figure that we're just talking about.
Well, this is already in the record. I don't need to review it now.
Mr. Loomis, are you aware of any plans to remove the property from agricultural use and develop it for residential purposes?
No,
Do you know whether it would be consistent with local zoning to do so?
I don't know.
Are you aware of any landowners in the project area who are interested in selling their land for residential development?
I'm unaware of any.
Are you aware of any restrictions that would be placed on local landowners associated with the project that would prohibit them from selling their land for residential development?
No.
I'm not being good.
Thanks so much for excuse. Who's next?
Our next witness is Mike Maroos.
It's Dr. Lewis, right?
There are all people open.
I do.
I see.
Mr. Burns, could you please state your name for the record?
Michael S. Morose.
And where are you employed and in what capacity?
I am president and owner of Morose and Company, which is a real estate consulting firm of approximately 8 employees located in Park Ridge, Illinois.
Have you prepared and caused to be filed in this proceeding direct testimony consisting of 6 pages and 1 exhibit?
I have.
And have you prepared and caused to be filed in this proceeding rebuttal testimony consisting of 4 pages?
I have.
Do you have any corrections to your testimony?
I do not.
Is the information contained within your testimony and exhibit true and correct to the best of your knowledge?
Yes,
And if I asked you the questions contained in your testimony today, would your answer be the same?
they would.
Mr. Moose, have you been in the room today for the duration of the testimony?
I have.
Have you heard concerns raised with regard to the size of the turbine that may be used for this project?
I have.
Have you analyzed any projects that have utilized the same or similar models as are being anticipated for this product?
I have, I believe, at least 4 or 5 locations in the last year and a half in the Midwest.
And do any of those projects that you have analyzed utilize the same models anticipated for this project?
I'm not a manufacturing expert, but I believe it's the same Vestas model. It's 656 feet tip height and, a little over 6 megawatts of capacity.
And with regard to those projects that you analyzed, similar models to this project, did you conclude that there were any negative impacts associated with property values as a result of those projects?
So the simple answer is no, but it was a concern because they're taller, it's generationally. We look at Montfort that, was 300, 350. Then we got next, which opened in 2023, it's about 555 feet. It's kind of been the evolution of the industry, and now it is at mid 600 level height of this Vesta. But what it does, it creates less density, which in my experience is a significant benefit. Because if we go to the original Montfort, you would need triple to quadruple the number of turbines to gain the same capacity. So as we look at these projects throughout the Midwest, density has been a negative. The lighting has been a negative, so the ADLS has been a huge issue. And the reduction of the density and 550 feet, it's tough to tell from the distance difference between 550 and 600, 650. They kind of did the 550, well, they did like 499, they did 550, they went to 595, now the 650, so kind of a monitor, but as they go on 1.5 megawatts to 6 megawatts, these significantly reduce the density, which actually reduces the sound. And I find, as far as the aesthetic characteristics, it's a significant benefit. But while I'm an economics guy, providing the economic benefits to the community.
Mr. Meredith, with regard to your analysis and investigation of the projects that we're talking about that are these larger models, did you, in the course of your investigation, were you made aware of any health or safety issues associated with those projects?
As I've heard today, which is typical, people are concerned with change. And they're concerned with impact, whether it's real or perceived. So I've heard, I'm not a doctor, I'm not a medical expert. It as an appraiser, you look at traffic, you look at smell, you look at economics, you look at trends of development. And I've seen people complain, but I've seen people complain about a lot of issues. So my daughter's mental health consulting business, and people have concern, but I have not seen anything that's quantified that would support that. But I obviously would defer to Dr. Albogan for that.
And with regard to these, that they have negative impacts on property values in the area.
No, with the proper siting and the proper setbacks with the ADLS, I think again, you're reducing the number of turbines by 1/4 to 1/2, and I think it's a net benefit. And you just don't have that density.
Mr. Mertz is available for examination.
Okay, before we do that, I just wanted to make sure, you're involved with an application, appendix, is that right?
Yes.
And it's appendix ZD, the market analysis? Oh, yes, I want to make sure we have that clear. All right,
That's good.
great. So who do we have for questions? We'll, start with our list of people. Why don't we just take you first, Larry, and go around from there.
Hi, Mr. Marus, my name is Larry Reagan. I just wanted to ask a couple of questions. Well, how long have you been in the business, or how long have you evaluated properties for, they're associated with wind turbines, or near wind turbines? How long have you been doing this?
Well, that's actually multiple questions. I've been evaluating property for over 45 years. I've looked at various energy type properties for well over 20, and wind properties for probably over a decade.
So a decade of wind turbine properties?
Correct.
Okay. Have you ever found where they have gone down in value, home values have gone down in value because of the wind turbines?
The answer is yes. In North Dakota, there was a very dense project that they didn't have decommissioning. It wasn't properly maintained. They basically had no ordinances, so they were dense and it failed. And that was a blight, just like if you have an empty office building, which we've seen in the last 10 years, the retail world has changed because of e-commerce. So we have a lot of empty, vacant, obsolete, shopping centers, the malls has been a nightmare. And so it has to go with modernization and function and economics. But basically the ones that have been well sited, well set back, follow the modern trends, take care of the shadow flicker, the noise issue, the setbacks, the ADLS. The answers are, in my experience as an appraiser, they're a significant positive economic impact.
Other than North Dakota, any other?
There was a project in kind of south central Minnesota that again was one of these late 1990s, early 2000s that was very dense, and obviously no ADLS. And I thought that property values hadn't gone down, but they didn't appear that they were consistently rising with the areas outside, but there were other economic impacts where there had been some, major changes in the economy that lost the hospital in the area, but to me, I didn't think it was a positive.
No more questions, thank you.
Yes.
Grace, your question.
You mentioned that the setbacks were
Can I
considered.
have your microphone in there?
Thank you.
I'm sorry. I'm Linda Grice, and you mentioned that the setbacks were consideration, influencing property values. What would you consider a good setback for a 650-foot turbine that would cause it to not influence a property value?
Very good question. And kind of goes back to that original discussion that in some of these original developments, they were as short as 500 to 700 feet. But again, the turbines were probably only 250, 300 feet tall. In my experience, for non-participants, I think 1,500 feet is a minimum. I see the ordinance of 3.1. I think that's a very good setback because it also takes into consideration the shadow flicker and also the noise. And it's just this thing with setback, as I've heard it many times, just make it farther and farther and farther, and then it makes it uneconomic. And if we were that concerned, we'd all be on the road with 3-mile-an-hour traffic limits. So there's kind of a mix where you hit a happy medium. And I think the 2.5 times minimum with, again, non-participants in the 1,500-foot range, that's what I find as a positive.
Thank you.
Third cross. Yeah, I know you have a question. Go ahead.
George Sportsman, you just mentioned we were talking about setbacks. You mentioned 3.1, 3.1 what? Is that miles?
It's 3.1 times the skip height. So if you're it's made easy.
Okay.
That if you're 500 feet, that's basically like 1,550 feet. This 656 feet gets you a little over 2,000 feet.
Okay. Thank you. And where are these, you said there were several areas where there were 650-foot wind turbines installed in Minnesota or something like that?
Well,
Right here.
Oh, can you hear me?
I'm sorry, I can't.
You said that there were several areas that had 650-foot wind turbines installed, Minnesota, that sort of thing. Where were those? And what do you know the names of those farms roughly, or where they are at least?
So the first is northeast Michigan, north of Detroit, up I think along Erie. Those are Erie. I don't recall the name of it. Another one is Piatt County, which is Illinois, which I think it's under construction now. It's not operational. And that is directly west. It's actually between Champaign and Normal. And I believe there's a couple that are under construction in Normal, where Dr. Loomis is from, that are approaching that mid 650-foot range. And in my report, I kind of discussed the economics that they're now generating $12 million a year in taxes. There's another one I'm aware of, I believe in Dual County, South Dakota. And there's one or two, at least, if not more, in Iowa and in Minnesota.
Okay.
But they're the new trend, as 599 was maybe my 5 years into it. When I first got into it, 499 was the magic number. But the density and the ADLS and the setbacks and the effect on sound and shadow have all gone hand in hand.
17 of these Badger Hollow wind turbines are going to be running within a 1.5 mile radius of the Iowa Grant school system. And I think if you throw in the uplands, there'll be about 25 within the mile and a half radius. If you had kids, would you send your kids to a school system like that?
I have 3 kids and 4 grandkids and they think they're cool. And my 11-year-old grandson has a model permit in his bedroom. So I would have no problem. And quite frankly, you hit a huge point that as I look at these rural communities, the economic impact to the schools have been so positive that they've improved the infrastructure, they've added roads, they've added tablets, and they've given them the ability to bring back better teachers, which has actually brought back some of the young people that want to raise their families there. But when the schools are bad, they don't go.
So you would send your kids to the schools that had, let's say, 25 turbines around the school building within a mile and a half radius? You'd actually, I know your grandson likes turbines, and that's.
Just ask your question.
Yeah.
Just ask the question.
Yeah, but the question is, would you send your children to a school system that had 25 wind turbines within a mile and a half of the building itself?
Well, first of all, my children are in the 30s, and second of all, my kids, particularly daughters, would make that decision. They don't always listen to their dad, but yes, I would.
You would?
Yeah.
Thank you.
All right, we're across. Go ahead.
Good afternoon, Mr. Morose. I'm Amy Hunt. I won't restate my association. I think you've probably heard that enough by sitting in the room this afternoon. Is it from your direct testimony? Would it be a fair statement that your review was of property values in the project area and the area surrounding it as a whole, and did not look at any individual properties inside the project area as an individual for impact? Is that a fair statement?
It's another good question. So I looked at the whole project. I drove the project on 2 different occasions on the streets, looked at the properties, also did Google Earth, but I didn't do individual valuations of each property. That is correct, but I was sensitive to the issue, particularly of the residential properties. And you look at, like we call it the view shield, where basically they have trees and evergreens protecting them from the wind and the dirt off the fields. And it kind of many times blocks any views, and many times the turbines will be kind of the side view outside the garage, so there's not a look. So I did look at the entire footprint, but I didn't go house by house.
Okay, with that, then I also heard during your testimony statements in regards to that the density, meaning number of towers, plays a part into property values. Is that a fair statement?
That's correct.
So would it also, if you haven't evaluated any individual properties within the project, and a property within the project is surrounded on 3 sides by a total of 5 turbines, is it a fair statement to say that it is at the present time unknown if there would be any property value impact to that property and the landowner?
So I look at that because that's always a concern. You know, would I have that issue? Would my wife have that issue, who is more sensitive to certain things than I am? And I think it again goes to setbacks and views and view shields. And very interesting project I looked at was in Lake County, Indiana, which was off of 65, heading south of I-80 going down past Purdue. And there is over a gigawatt of wind, which is like a nuclear plant. It goes on for about 20 miles. And looking at the matched pairs as I did in this situation, property values were actually going up higher because the tax revenues were so strong and robust, and they had no property tax increases in a dozen years because of the success of the wind. And, some of those houses could see 15 turbines. So I think, again, density is a concern, but it goes to setbacks and it goes to the ADLS. That being said, when I go to a project and I like to go at night and I can see the blinking lights for quite a while, But then when you get in the project, it's like, where are the lights? Well, it's kind of the opposite when you go to a Walmart, where they're coming down on you. When you get into the project, they're going up. They're up lighting and you don't see them. But I think properly done and properly set back, it's not a problem, but I can fully understand your concern and, you know, wanting to protect your house. And, you know, 5 is something, you know, that I'm sure the developer's gonna look at. I think we're gonna pay for your concerns.
Thank you. One additional question. Your previous statement was, you know, that you yourself have experienced when you've been to home at night and you could see the blinking lights of the turbines off in the distance. And with that being said, and with our family farm going to be surrounded by 5 on 3 sides, that could be a potential issue for us, correct?
Objection, outside of so this testimony calls for speculation.
So
I guess it's, well, it's sort of vague until, I think he answered the question in his last answer, particularly about the uplighting of the ADLS.
Yeah.
But if you have another question, I'll let you ask another question if you want to. It's similar to that, I'm sure you could figure out a way to rephrase.
Circle back to my original question, or the previous question I was trying to get answered, and I appreciate this, the testimony that was offered. But the question truly was, at its heart, is it safe to say that as we sit here today, that there has not, you yourself has not performed any studies or made any review of what the potential property value impact could be to our family farm as an individual?
Objection has to be answered.
Overall.
Can I ask how many acres you own?
At 329.
Okay. So, what I found was go to the farmland. Because of the significant revenue that's coming into the community to pay for the 19 turbines. That enhances obviously the taxes, enhances the economics of the area, enhances the schools, the public, usually the infrastructure. And then it puts more money into the community to upgrade their machinery. And it creates a desirability and generally raises agricultural prices. Clearly, the properties that are getting leases, there's people chasing those deals all over the country, paying premiums, like a net lease, you know, with a retail store. So I think your ag land is going to be enhanced. I think your residential property, again, with the setbacks, again, based on my experience looking over 60 wind farms, would probably look doing 300 value impact studies for a lot of different things. Industrial, landfills, waste transfer, churches. In my opinion, properly done, it's my strong opinion, it's gonna be, and you've heard, and you've seen David Lewis's report, it's gonna be an economic enhancement. It's gonna be another part of the agricultural economy that's a lot more stable because you're not impacted by commodity pricing, economic climate issues, tax laws, etc. So it's a stable force and it just becomes part of the new normal.
No further questions.
Sorry. Cross, low cross, yes, go ahead.
Good afternoon, sir. My name is. Good afternoon, sir. My name is Eric Olson, and I'm here with Wisconsin Policy Monitor LLC. Could you help me with the pronunciation of your last name? Is it Marus?
It's very good, morose. I've been called worse though.
Me too. We got that. Mr. Marus, you spoke a little bit about how some situations that you had studied over the years, such as one which was, several maybe that were too dense. Too dense.
Correct.
Yep, they
Just
caused,
too dense, and, had basically no zoning, and there was no enforcement, there was no decommissioning, and they were poorly managed by underfunded companies.
well, what is the importance of the decommissioning? What do you mean by that?
Well, for the landowner that, you know, has, burdens by them, they don't want to see them just sitting there and not maintained and wondering when the heck they're gonna come down and who's gonna pay for it. It's just like you go through certain areas where there's old oil and you see the little, pumps that are in the ground that have just been sitting there. You know, that just shows failure, it's just like vacant storefronts or, you know, a vacant Walmart or a vacant Kmart. So, that's why it's important to have, you know, go for high quality developments like the state of Wisconsin does.
All right, so I think I understand what you're saying now. So you're saying that one condition that can cause, that you have studied, that you found to cause negative impacts to property values, were situations where there was a wind turbine development that had failed, but there wasn't a decommissioning plan in place, so it was sitting there idle. Is that what it is?
Well, it was one of a variety of issues, you know, with the density, with the poor maintenance, with poor economics, they couldn't pay the landowners, they weren't making any money. So it just all added together and they basically had virtually no decommissioning. The numbers I heard today, I think were 250 to 275,000 compared to zero. That's a significant difference.
So you think that having that money set aside in the types of numbers that were talked about here would assuage any concerns?
Object to the extent that.
Is that what you're saying?
Sustained.
Okay, so I'm just trying to understand what the testimony was. Is the testimony that you have detected property value impacts in situations where the public's perception is that there isn't a good decommissioning plan in place?
Again, it's one of 5 to 6 items that you need to check off. You need to have good zoning, you need to have good setbacks, you need to have a good developer. You need to have fair decommissioning, all the things that this project has. The ones that have failed were too dense, poorly funded, no zoning, and no decommissioning. And the other thing is, I mean, it's really a business model that having, leases in place, whether it be Walmart or Microsoft or Alphabet, that provides a financial commitment. That's how these things get built. They're generally not built until they have that economic model that protects them.
I just want to make sure I understand what your criteria are. So what do you mean by the zoning? I'm sorry, the zoning of the municipality?
No, well, that's a good question, but in the state, if you're over 99 megawatts, you have to come here and you have to meet the criteria, the 3.1 setbacks, your sound limitations, your decommissioning, your shell flicker limits, and other criteria that makes it a good project within reason. And again, we go back to the history of these things, the early ones, there were many that were not done right. Throughout the country.
In the cases of these early wind turbine developments that you analyzed and you found that they were causing property value impacts to certain properties, what range of impacts did you find, if you can remember and just sit here today?
Like I said, the one in southern Minnesota, there was no negative but the market wasn't moving as fast as comparable areas, but again, there were other things impacting it. The ones in, North Dakota was very rural. There wasn't a lot going on economically there anyway. I don't recall what the range was, but it was basically a failed project that needed to be cleaned up. And until that was done, it was not a positive. And part of it goes to absorption time of marketing. If your typical marketing time is 2 to 3 months, if you have something that's a problem, that could impact. So maybe the prices don't go down, but your marketing time increases. But again, these are the bad examples as opposed to the 500 good examples that have been very successful and really resurrected the economics of many communities in Middle America.
You spoke about the importance of the setbacks and you referenced the 3.1 setback, correct?
Well, I referenced that as what is here impacting the subject, and I had said 1,500 feet or probably 2.5 times setback, I think is a reasonable number.
Okay, so is your opinion that properties that are, I guess, really your repaired sales look largely at rural residential properties, correct?
Correct.
Okay, and so it would be your opinion that rural residential properties located 1,500 feet or more from one or more of the turbines that's being proposed to be built in this project will not experience any diminution in property value. Is that a fair synopsis of your opinion?
In my opinion, that's best practice. There's indications of properties that are 1,200 feet away that haven't had a negative impact. But I'm saying, based on the increased height and what I see, I recommend at least 1,500 feet for non-participants. Participants, it's America. You can, if they want to take it shorter and make their decision, I've seen that happen. But that's a decision a landowner makes.
You have a 228 page appendix that you authored, I suppose, in conjunction with others at your firm, maybe, but which page do you state that opinion on?
Where are you pointing to?
Oh, this is exhibit,
It's okay, and appendix Z, the application.
it would be Z. Yeah, the actually market impact analysis.
Is there a page number?
I was asking him what page the opinion that he just stated was stated on.
Sure, on page 2 of that exhibit on executive summary, it kind of goes through these various recommendations that I made. I can read them, but there's a whole.
That's okay, please don't.
Okay, so, would you agree that, as to, are you familiar with the terminology of a safe line?
A what line?
I guess, a safe line?
Safe line?
Yeah.
I'm not sure I've heard it, but I can.
Okay.
It depends on the situation. I believe I understand.
Okay, I think it's used a lot in conjunction with, valuing properties that are on linear pieces of right of way, such as a highway. And it's the distance, the setback distance that's required to be outside of the zone that's expected to have a negative or detrimental impact on the value of a given type of property.
Just so you're aware, I've been involved with over 1,000 right-of-way cases in the Midwest, including working from Milwaukee Sioux. Property in Wisconsin.
Do we agree on that definition?
Yes.
Yes. So would the safe line, as we've just defined it for this project, be 1,500 feet from turbines?
For the tip of an occupied non-participant residence.
And then as far as what you're terming, participating residents, that would be a residence either with a lease in place or what has been called a good neighbor agreement in place, correct?
Correct.
Are you familiar with the good neighbor agreements that are being used in this matter?
Generally, but not specifically.
Have you, over the years, ever evaluated whether or not transmission lines can impact the value of residential property?
Yes.
Okay. Are you familiar with a published article by professors Lyman and Moulthorpe about the impact of high voltage transmission lines on property values?
I am not.
Okay. Would you agree that the appendix to the application, which is your market impact analysis, does not contain any analysis of the potential impacts of any transmission lines that may be associated with this project?
I agree. I agree that it's not in this document.
Are you familiar with the appraisal and real estate valuation terminology stigma?
Yes.
Stigma, would it be fair to say that that is a condition affecting a parcel of property that has a real or perceived effect on the property that causes a decrease in property value?
I'm smiling, because the answer is yes. There's a couple of books out that I've actually participated in, and many times happens with mass murders. John Gacy's 17 Below is about 3 miles from my house. Dahmer was in Milwaukee, and then the Manson thing in Southern California. And so there's kind of studies of those horrific activities. On the other hand, we have a situation in Chicago where the Pope grew up in this little poor community where his house sold for 60 grand. Now the lucky remodeler wants 250,000 and the city wants to buy it. So it kind of cuts both ways.
Right. And that was a beautiful discussion of stigma right there. It's almost a cultural phenomenon, fair to say, because it deals with the perception of people on and how that interrelates with real estate, correct?
Well, it does, but I've found not everybody likes everything, and there's negative perceptions and positive perceptions. And any house that goes to the market, there may be 10 people to look at it. 5 may hate it, 3 can't afford it, but if you have 2 that really like it, you created a market. So if you say the 5 that hate it, it's a stigma, but it sells about the asking price, I'm not sure that's really a stigma, it's a matter of opinion.
Would you agree that if a stigma develops at a future time in relation to wind turbines, the effects of those turbines on the value of residential property would change at that time?
Objection calls for speculation.
Sustained.
Okay. You did not consider in your market impact analysis whether or not the turbines that are proposed in this case will cause a stigma that could affect the value of properties in the project area, true?
That is not true. I consider that in every project, every appraisal that I do, any potential study that I do, it's a consideration. But when it's not real or not proven by the market, I don't do an analysis in my report. I've done over 12,000 appraisals, 400 impact studies, and clearly well-designed projects such as this In my experience, the market has indicated do not have a stigma. Are there certain people that don't like them? Yes. But again, the benefits it provides, it creates the market and the values are going to negatively impact.
Okay, so. For example, on page 166 of your. Report, can we call your exhibit CD, your report, your session CD, can we call, Your Honor, can we call it the report, or do we need to call it exhibit ZD to the application?
We can call it the report for the purposes of this question.
Okay, thank you, Your Honor. So in the in your report on page 166, you talk about some studies that considered area stigma, scenic vista stigma, and nuisance stigma that might be caused by wind turbines, correct?
Correct.
And those studies found that as far as those sales were concerned, there was not statistically significant evidence that the home values near the turbines were affected, correct?
Yes.
Okay. What specific guarantee can you give as we sit here today that those types of stigmas will not develop over the 60-year lifespan of this project?
Sorry, that what your lifespan? 60?
30 to 60-year lifespan of this project.
Objective form, also calls for speculation.
Rephrase.
Yeah. You did not develop any opinion as to whether or not a stigma that would affect the property values in the project area was likely or unlikely to develop over the lifespan of this project. You dealt with the time period that you evaluated, correct?
Well, first of all, I consider current market conditions and as we're all experiencing with tariffs, you know, changes in interest rates, price of oil, things are changing. So I can't speculate as to change, but with the history and the evolution and the positive impact of renewable energy, and really it's fueling, whether we want to recognize it or not, artificial intelligence, AI, which is exploiting data center, which is creating significant economic positive impact where they need power. You know, what's gonna happen in 60 years? First of all, I wish I could be here in 60 years, but it's tough to say, and things do change, but based on this, again, it's gonna be part of the agricultural economy that's gonna be a positive, and that part is good. What's gonna happen in 10 years? You know, is there gonna be potentially a drought or a recession and values drop? That's gonna hurt everybody. Is there gonna be an explosion because of the economic benefits? The landowners going to participate, say they're gonna give 25% of their increases, you know, to the wind farm developer? Of course not. So, I mean, it kind of cuts both ways. But the positive, there's no demand on the infrastructure of the community. You add jobs in short term, you add a lot of jobs, and then you create this new economy. And Iowa's a great example, and you look at the ag community, it just changes, but the ones that can adapt and go modern and take advantage of it are the ones that are winning. And the economy of Iowa and the economy of Wisconsin is doing very well, much better than our economy in Illinois.
Would it be fair to state that your opinion is that, provided that the measures and considerations that you stated early in your testimony, including zoning setbacks, a responsible developer, decommissioning, and leases in place are all met, that negative impacts to property values outside of the 1,500-foot safe line will not be expected as of the date of your report or in the reasonably foreseeable future thereafter?
I'll object to the extent that it mischaracterizes the testimony.
Does? Do you have a response?
I don't think it does. I mischaracterize his testimony.
I'll have an answer. Go ahead.
Not sure I heard the end of the question, but I believe, based on all the factors I considered in my report, my study, my experience, my analysis, it's my strong opinion there will be not a negative impact on the property values.
You couldn't hear my question, is that what happened?
Well, I heard till about the last 6 words.
Oh, okay. I said, would it be fair to summarize your opinion as being that so long as the factors you discussed throughout your testimony, including zoning, setbacks, a responsible developer, a decommissioning plan, and having leases in place were complied with, that there would be no value impacts to properties outside of the safe setback at the time of your report or in the reasonably foreseeable future thereafter? Was that your opinion?
Your Honor, I'll lodge the same objection to the extent that it mischaracterizes testimony, also as been asked in the past.
Well, there was some confusion whether the witness heard the question, so I'll allow an answer. You just agree.
Yeah, there was a lot that went with it. My understanding is, in my opinion, based on all those facts, there would not be a negative impact within the project footprint, nor reasonably outside of it. There would be an enhancement for the area.
Okay. Thank you very much for your testimony, Mr. Burris.
Thank you.
All right, it's all across. Yes, you know,
Gotta get one more?
looking at the time, I'm not gonna let you ask another.
Take 10 seconds.
I just can't.
Okay.
We need to move on.
Okay, thank you.
Okay, go
I
ahead.
just have a couple of follow-ups, Your Honor. Mr. Murray, did you analyze the density of this project in association with your conclusions of property value?
I did, yes.
And what did you conclude?
Very low density, over 10,000 acres with 19 turbines. That's very low density and population density. It's in my report, but I think within the population density, it's less than 25 people per square mile, which is low.
And Mr. Murris, do you believe that the project has been designed, including with regard to setbacks, such that the negative property value impacts are not anticipated?
That's correct.
You were asked a couple of questions about transmission lines and impacts of transmission lines on property values. Are you familiar with the transmission infrastructure that is anticipated by this project?
I am.
Have you made any conclusions with regard to whether the transmission infrastructure associated with this project will have negative impacts on property values in the project area?
I looked at the location, the length, the height of the poles, the spread of the poles, and particularly the distance from 2 occupied residents and 1 unoccupied residence. And generally, the criteria is a 200-foot setback from the transmission line with the poles. You know, it depends on the house and the view shed. Sometimes the pole is a problem, but here, I believe the 3 of them probably average close to 1,000 feet, and the transmission line is maybe 1/4 mile, so it's pretty enormous. And it's sitting kind of on a substation that's already there in existence.
But just to put a finer point on that, did you conclude that there will not be negative impacts associated with the transmission infrastructure for this project?
Yes, it's not my report, but as an additional analysis that I was brought aware of and that I studied in the last 2 days, that's correct.
I have nothing further.
Okay, so I just wanted to point out, I know we mentioned that the project proposes 19 turbines. I think that's the answer when you were giving answers, you were assuming a 19 as the number of turbines in
in the project.
Right,
Project.
but recognizing, I think permitting is 24, 25, but 19 was my assumption of what could be built.
Okay, I just wanted to clarify, because on your report, page 9, it does say that the project description, you use number equals 25, it consists of the project is supposed to consist of the 25 turbines. So can you just clarify what you meant by
Sure,
that?
but
Yeah, go ahead.
again, because of soil conditions and, setback issues from houses, that's the total number, but then what they would build would be 19, maybe 18. So they can't, because they've got 118 megawatt capacity.
Yeah,
They're limited to that.
but your analysis doesn't change. I don't know how to ask the question exactly. So you just answered your questions related to a 19 turbine project, but your report seems to indicate that we were studying a 25 turbine project. Is there any? Do you need to clarify anything about the answer you gave today, given the scope of the report that we have in the record?
The only thing I would say is the 118 megawatts. And, the Vestas size, my assumption was 18 or 19 turbines, but they would have 24 or 25 sited. Which is, typically there's 10 to 20% more sited. But it was always focused on that size, 118 megawatts.
Oh, so when you said 25 turbines, you were talking about the proposed sites, including alternate sites.
Correct.
But there are more than that in the proposed project, more alternate sites than that. You didn't know that, okay. I didn't know if we had a point of confusion here or not. Okay, thanks very much.
Thank you, Your Honor.
Oh, and good work, we'll go off the record. Good work getting the comparison with Pope Leo and Jeffrey Dahmer in the record, in the same pants.
Say anything about the Bears?
Not this time.
We get Packer country, I almost didn't. I have cup tickets tomorrow night and I've given them little kids.
All right,
But they're playing the Brewers.
so what do we have next?
Your Honor, Joanne Blank is next.
And off the record, Your Honor, before we take the next witness, just as a housekeeping matter, I was just curious if this is gonna be the last witness or what our anticipated plan is for.
Yeah, well, going even slower than I anticipated.
Just looking at that, it's 4:30 right now.
So how many witnesses do we have left from the applicant? I might have not been marked them all on here.
We have a total of 6 remaining.
One of them being Hankered.
Correct. We've got Mr. Hankard, Ms. Blank, who's on the stand currently, Dr. Ellen Bogan, Mr. Patton, and Dr. Howard.
Okay. So are there witnesses we don't anticipate full on across for? I think maybe Ellen Bowden and Hankard, we may want to push it to tomorrow when we're fresh, but
My guess, and it's only a guess, Your Honor, but my hope was that there will be the least amount of questions for Ms. Blank.
yeah, well, okay. So. And Kurt's, maybe, what do we think about Kurt's? Lots of questions.
There have been a lot of issues raised that implicate his testimony, so I do anticipate his testimony may be, his cross-examination may be more detailed.
Okay. Well, just thinking into the future, how much cross do you anticipate of the interveners?
It's fairly targeted. I don't anticipate lengthy cross-examinations of each of the interveners.
Okay. So.
With the exception of Dr. Kunsch, I should say.
Right. So why don't we take Blank, we'll probably just, and see if we can get one other witness in. That'll be quicker. So Kerner and Howard. We're done.
Turner has already testified.
That's the one I was missing, yeah.
And Howard, is our witness who is currently in Europe, so set
Oh.
on the first thing term.
All right.
I do anticipate his testimony will be relatively brief. I don't think there's been a lot of cross indicated.
Do we have a lot of questions for Kurtz? People know here. Just just you, maybe?
Kurtz is the engineer.
Yeah. Oh, that's right, so there's, yeah. Okay, really. So we'll probably take blank, and then how about anyone from staff or? Possibly a staff person who would be quick. But interveners might have questions, right? Yeah.
Your Honor, we'd be happy to call
Andrew Cal, all right, yes, let's get in. Well, you may have some cross too. All right, we'll try blank and Cal, and then that's great, yeah. Thanks.
And I don't have any good cold project.
Oh, no, you're working on your line.
Your Honor, just one point of clarification. I'm not sure if the doors lock at 5
I
from the outside.
They are not supposed to.
Okay, well, just in case anyone leaves, I don't know if you want to make a disclaimer.
Way it works is the doors back here will lock, not from the inside, but the outside. And then, but this door should be open, you can get back into the room, into the building, but you might want to test it out. It should be after 5:30, the door is locked. But we told Capitol Police. So if they got the message, they should be keeping the door unlocked, but I didn't actually make that call this time, so I'm not sure. All right, let's swear you in, raise your right hand, swear or affirm, the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Please state your name for the record. Glenn Blank. And where are you employed and in what capacity?
I'm employed at Stantec Consulting Services as a senior associate, senior scientist.
Have you prepared and caused to be filed in this proceeding direct testimony consisting of 9 pages and 1 exhibit?
I have.
Have you prepared and caused to be filed in this proceeding rebuttal testimony consisting of 4 pages?
Yes,
Do you have any corrections to your testimony?
I do not.
Is the information contained in your testimony and exhibit true and correct to the best of your knowledge?
It is.
If I asked you the questions set forth in your testimony today, would your responses be the same?
They would be.
Ms. Blank, were you in the room for testimony regarding whether there are any non-participating property owners who will exceed regulatory limits?
I was in the room.
Did you analyze whether there are any non-participating properties that will experience shadow flicker in excess of the limits set by chapter 128?
There will not be any non-participating receptors that are in excess of the limit.
Thank you. And with that, Ms. Blank is available for cross-examination.
Okay, so just curious, I don't have witness blanks exhibit on the offered evidence list, so. Just want to make sure, is it, I'll read out the PSC number. You'll just stay on this, 536850. That looks like it.
That's correct.
Okay, so any questions for witness blank?
One question, Your Honor.
All right, so introduce yourself. And do your affiliation too, because they might not have heard it before.
Good afternoon, Amy Hunt, representing the trustees of 435 County Highway E. Brewery. Were you present in the room for the earlier conversations when the map was displayed showing where our farm is located within the project area?
Yes, I was.
And when you reviewed that map, do you have any recollection that during your study was the residents associated with that land, was that reviewed as a participating landowner or a non-participating landowner?
I believe if I have the receptor correct, that I was looking at, we reviewed it as a non-participant.
Thank you.
Okay, that's it. Anyone else?
Yeah. Okay. Oops. Good afternoon, Ms. Blaine. My name is Eric Olson and I'm here for Wisconsin Policy Monitor LLC. Would it be okay if I ask you a few questions?
Certainly.
Thank you. All right, first of all, your principal role in this procedure was to analyze the potential impact of shadow flicker that might be caused by the proposed project, correct?
That's correct.
Did your analysis of shadow flicker include an analysis of other visual impacts that the property could have on people in the project area?
No, it was restricted to shadow flicker.
Okay. Do you hold the expert opinion that the Badger Hollow Wind Project, including the turbines, transmission lines, and all other infrastructure, will not cause any type of sickness to any people in Wisconsin?
Objection, this is outside the scope of Ms. Blaine's testimony.
This is similar to the last witness. Can you question that?
Question, do you hold the expert opinion that the Badger Hollow Wind Project, including the turbines, transmissions, lines, and all other infrastructure, will not cause any type of sickness to any people in Wisconsin?
I guess if you could lay more foundation on that, related, because.
Okay. Ms. Blank, your sole responsibility in this case was to formulate an expert opinion and to testify at this hearing if necessary on whatever impact the proposed project might cause to people in the state of Wisconsin due to shadow flicker, correct?
Yes, my role was to quantify the impact of the shadow flicker on receptors.
So in fact, you yourself do not hold any expert opinion as to whether or not the Badger Hollow Wind Project in its entirety will cause any type of sickness or other negative health effects to any people in Wisconsin due to shadow flicker. You don't hold that opinion, do you?
I do not, I am not a medical doctor, so I would not offer that.
So in reality, the scope of your expert opinion in this case is actually very limited. Well, I don't want to say very limited, it's limited. Limited is enough in itself to quantifying shadow flicker that will be caused by the proposed project. True?
Objection, Your Honor, the report is in the record, the testimony is in the record.
Yeah.
It says what it says.
I think that was asked and answered, so let's move on.
What is your definition? What is your working definition of shadow flicker that you used in your report?
Is that in the report?
It is in the report.
Can we rely on the report? for
Yeah,
that?
rely on the
Questions?
report.
Where in the report is that?
Under the section 2.0 and 2.1, the description of shadow flicker. Shadow flicker is a term that's used, and I've made a.
That's okay.
No, okay, so
Off the record, though, are you looking at an application document?
I'm looking at the at our report, which was appendix C.
Okay, so let's get on the record, so the witness is referencing the shadow flicker report is in appendix Z of the application. And we're all on the same page with your revised version. That it's like there's a revised version and an original. Like revised was filed October 14th, 2024.
2025. Revised is
All
February
revised.
3rd,
Oh, yeah.
2025.
Yeah, there. So that's correct. That's what we're all talking about.
Yes, that's correct.
Are you ready, Attorney Olson?
Yeah.
Right.
Would you agree that the reason that it is important to quantify shadow flicker is to ensure that people are not negatively impacted by it?
I've acted outside the scope of this witness's testimony. I think this question is really targeting the purpose of the regulation.
Yeah, sustained, that's the regulations with their, why they're doing.
Okay. As we heard earlier today, there are questions about which sites the turbines will be constructed on. And then there was additional testimony that each site might vary by up to 250 feet in any given direction. Given those two pieces of testimony, how is it possible for you to accurately quantify the shadow effect?
That's a great question. Our report is actually extremely conservative. Our study was, we actually took all of the potential 24 locations into consideration at the same time. So the overall shadow flicker from 18 or 19 turbines is going to be less than what is in our report. As far as the movement of the turbines 250 feet, there may be a rare case where a 250 foot movement would affect the shadow flicker either more or less. And that we would be doing another study. Invenergy has committed to doing a study, a refresh of the analysis with the final locations.
So I think your report basically said that it was generally accepted that shadow flicker becomes imperceptible after about 1.25 miles. Is that correct?
Yes, it actually becomes imperceptible generally at about 10 times the rotor diameter. We assess out to 1.25 miles. Very, very rarely will you see shadow flicker that far out. And if it is, it's very dissipated.
Okay, and then in your report, I think it was indicated that you determined that there were approximately, was it, unfortunately, I'm now suddenly unable to find was it 778 receptors?
There were 707 residences and occupied community buildings that we assessed.
Okay, so there were 707 occupied residences and community buildings. And how many people did you estimate might be impacted?
We don't assess the number of people. We would have no way of doing that. We assess the structures themselves.
Okay, thank you. That's all my questions.
Other cross and feeling, go ahead.
Just one, George Schwartzman, this is Wayne. Knowing what you know about shadow flicker, would you buy a house 1/4 mile away from a wind turbine where you were exposed to shadow flicker year round?
I would certainly purchase a home that was exposed to shadow flicker as long as it was within a reasonable limit, which I believe is the 30 hours. And I have actually considered a home within that distance.
Thank you.
All right, other cross. Commission staff, Any questions? No. Redirect?
Nothing
All
further,
right,
Your Honor.
yeah. Thanks very much, your excuse. All right, so we'll take one more. Ms. Cal?
All right, Renew Wisconsin calls Andrew Kell to stand.
You earned your fee today. You got him out of here the first day. There.
It's not an endorsement, is it? Your
No, absolutely. Right hand, you swear or affirm the whole truth, nothing but the truth.
I do.
All right, go ahead.
All right, good afternoon, Mr. Kell. Could you state your name, position, and who's be happy testifying?
My name is Andrew Calvin, Policy Director for Renew Wisconsin.
All right. Are you the same Andrew Kell who filed or caused to be filed direct Renew Kell and exhibit Renew Kell 1 through exhibit Renew Kell 5?
Yes, I am.
And are these documents true and correct to your knowledge?
Yes, they are.
Do you have any changes you'd wish to make to those documents at this time?
No, I do not.
All right, Your Honor, I pass the witness for cross-examination.
Okay, I believe Linda Grice gets questions.
Hey, yes, thank you. Hi, my name is Linda Bryce. I have a question, if that's okay?
Yeah.
Yeah, and just get closer to the mic when you.
Um. I believe you were the one that have a program that quantifies the CO2 reductions and all of that. I was just wondering on some of those, if you have the actual calculations and what the factors are that are included in each of the calculations. Do you have a table of that or anything?
Yes, I believe that was described in my direct testimony, and I provided an exhibit as well with regards to the results. I used both the Environmental Protection Agency AVERT model to AVERT, AVERT model to estimate the carbon dioxide emission reductions, as well as the EPA COBRA model to estimate the health benefits associated with non-greenhouse gas emission reductions.
I saw that, but what I was wondering is if you have the information of what factors go into that to estimate each of those.
Yes, let me find that in testimony for you.
Okay.
So my testimony begins to discuss the emission reductions on page 5, so this would be direct Renew L5. There's quite a bit of description for the EPA AVERT tool there, how it works with regards to the interconnected transmission grid and the wholesale electricity market. Talking about the benefits and drawbacks of using the model, all the assumptions that are contained within the model, and then finding the initial results that I ran for that Halloween.
So
Those results are available on Direct Renew Cal 10.
I don't see the assumptions that you used. I just see you have this fantastic program called AVERT. I went to that website last night because I thought I could find out more information there. And it was an EPA page, but last night anyway, most of it's not working. I think it's down.
Okay.
So you used AVERT to figure this, but I just needed to know what factors go into that analysis.
Yeah, sure. I have put your attention to
On page 9, you have some things. Where it
There's
just
a-
talks about software tools.
Right, there's so the AVERT model utilizes a generation data set called eGrid that contains all the generators in the United States and their associated emissions, and comes up with an annual average of pounds of CO2 per megawatt hour across the Midwest wholesale market grid. Trying to find a specific page where that average number is. It's around 1,600 pounds per megawatt hour.
I guess I'm more interested in what figures went in to determine that number. How was that calculated?
But Your Honor, I think you just answered that.
No, you didn't.
So I think what I'm gonna do is, I'm gonna have you do a renew and you, Ms. Grace, discuss this offline. This sounds like this might be more appropriate for discovery. Maybe she's looking for like a, data that goes into AVERT. I don't know if that's available or not, but that might just cut the crosstalk and get her an answer. So if we treated it more as a discovery request, just to better understand the model. Do you have any questions
I have other
specific
questions.
to the, hang on, any questions specific to the results that witness Cal is proposing?
My main question is, like, on page 10, he said there were 597 short tons of CO2 will be avoided due to the production from Badger Hollow Wind in the first year of operation alone. And I'm wondering if those calculations are including all of the carbon emissions in the first year by the construction and the building the turbines and all of those things? Or is that just the emissions without all the figuring of the cost of getting it up and running?
So what you're describing is essentially a full life cycle analysis, so the AVERT Cobra tool does not perform that analysis. The emission reductions that are summarized in my testimony are describing the reduced emissions from fossil fuel generators such as coal-fired generators, natural gas generators in the state of Wisconsin and neighboring states as well, that will produce less energy and therefore produce less emissions of CO2 as well as non-greenhouse gas emissions such as nitrogen oxides and particulate matter.
But wouldn't you agree that you would need to consider totality, not just what's gonna happen after the turbines are up, but the totality of all the carbon emissions and different emissions while they're being built, plus after they're up? And
One could perform a full life cycle analysis that compares all generation resources together. I did not perform that type of analysis in my direct testimony.
I had on page 11, you talk about the project expected to operate for at least 30 years. And during these years, Badger Hollow Wind would continue to reduce grid emissions until the grid is entirely composed of zero carbon emissions resources. So is Badger Hollow Wind going to allow the grid to be composed of zero carbon emissions completely?
So Badger Hollow Wind, along with many other renewable and clean energy projects, are moving Wisconsin towards a zero carbon emitting generation future. I described that in a separate section, in which I talk about the zero carbon study that was submitted. Believe that is exhibits 3. That's exhibit reading L3. This is a summary report of the model of a zero carbon future by 2050. And Badger Hollow Wind would definitely be part of the generation transition needed to happen in order to have a zero carbon future occur.
So if we have a zero carbon future, can you estimate the number of wind turbines it's gonna take to get there?
Yes. Let me find that in my testimony. So on Renew Cal 16. It states that Wisconsin will need over 27,000 megawatts of wind generating capacity to serve all Wisconsin's load needs by 2050.
Okay, and how will that be impacted by the AI centers coming in to Wisconsin that are putting in gas generation?
Yeah, great question. So the study did provide forecasts of Wisconsin's growing electricity usage. At that point in time, it was considering the electrification of transportation sectors, industrial sectors, and other sectors as well, which led to massive growth of electricity use in the state of Wisconsin. At that point in time, it did not forecast the growth of AI data centers that we're just now starting to see as well. So that, if the study were revised, it would have revised forecasts and probably include forecasts for data centers being added to the Wisconsin's energy usage.
And how will that be impacted by? Oh, I forgot my train of thought. Had another one there. The MISO grid, how will the MISO grid be impacted? Because I'm reading a lot in the MISO publications. If I've got some properties hooked up to electricity with MISO and they're saying they need more reliable sources. How will that happen with all these wind turbines?
Objection, Your Honor. We have a question.
Can you have a question while you're?
I don't have a question. There's a question out there. I'm not sure what the question is. There's a couple statements about MISO.
MISO, how will all the wind turbines impact the reliability of electricity in MISO that's being talked about by the CEOs of the co-ops?
Your Honor, I'm gonna object to the extent there's this question about talking about CEOs and statements outside of the record here.
Yeah, I was just stating the objection. It seems to be statements, this is an issue outside the scope of the project. If you can ask a question about wind turbines and this project in particular, that would be helpful to the record.
Okay, the EPA AVERT tool estimates, your testimony says the EPA AVERT tool estimates several non-GHG emissions that are avoided due to reduced production from existing fossil fuel generators in Wisconsin and the MISO region. What are those?
I'm sorry, could you point me to the testimony?
It's on page 12, line 10 and 11, 12.
Yes, those are in table 5 at the bottom of page 12. In particular, the AVERT results are transferred to the COBRA tool to analyze the health benefits of non-greenhouse gas emission reduction, and those in particular are particulate matter 2.5 in Old Free, which is represented by Ozo.
Okay, thank you.
Other crops? Go ahead.
I'm Jordan Sportsman, Mr. Gell. You threw out a number there, 27,000 megawatts by 2050, was it 27,000 megawatts?
That's correct. I believe it's in the page. It's page 16.
So how many times, how many times increase would we need to? How much of an increase would we have to have in terms of how many times do we have to increase the wind terms that we have now? Okay, would we have, okay, could we, would we have to double the number of wind turbines we have now, or triple them, or quadruple them? There you go.
So on page 16, I write that if the Badger Hollow Wind and Whitewater Wind project are in service by 2028, approximate cumulative total of 1,015 megawatts would represent 4.8% of the 21,000 megawatts that have been needed in Wisconsin by 2050. So actually, to correct myself, 27,000 listed above includes out-of-state wind as well.
I'm sorry, our statement.
The 27,000 megawatts listed above includes out-of-state wind as well. And the 21,000 megawatts of wind was in that model forecast that would be needed to be cited in the state episodes.
So in other words, you're saying right now, wind in Wisconsin is producing about 5% of our electricity. So that's 1/20th of the electricity we would need. We'd have to increase our turbines by 20 times.
I'm not sure what the question is.
The question is basically look at how many wind turbines we have right now. And how much electricity, how many more wind turbines would we need? Would we need to double the wind turbines we have right now, or triple them in the state of Wisconsin to reach this 27,000 by 2050? And then we'll also have solar going along with that. Let's say solar and wind would increase at the same rate. Would we have to double, triple, quadruple the number of turbines that we have now up to? See what I'm saying?
I'm gonna object to speculation to the extent that this is calling Mr. Keller know the amount of wind turbines in the state and then performing ad hoc analysis.
Yeah, okay, so sustain the objection, I mean, the witness has an estimate based on current, maybe outdated forecasts for load and indicated 27,000 megawatts of wind is needed. So we know what and I guess the question maybe for witness Kel would be, how would you calculate the number of, so if you look at the current proposed project, 180 megawatts, how many of the current proposed projects would need to be put in place to meet the 27,000 megawatt need?
We would need almost 20,000 more megawatts of wind sited in the state of Wisconsin.
So roughly eyeball.
So you can simply divide 118 into 20,000. You can get the number of projects that was the same size as this one. Equal what's needed, right? Is that? Did I do that right or? Okay.
That's gonna be a lot of anyway, yeah, one more question then too. When in this model, I was not prepared for this. I didn't know who's with for this number coming up. So in your model, do you include the CO2 inclusion that is produced in the production phase of the wind turbines, and then we have the installation phase and then the operation phase? I think you're talking about the operation phase. Once the thing is up, it's not producing very much CO2, but there's a lot of greenhouse gas and pollution produced in the production phase. Maybe blades. Have you ever read a book called Cobalt Red?
What was the book called?
Cobalt Red.
Cobalt.
You should read it, okay? So I believe that when you add, by the time you add up all.
Okay, we don't want to be testifying. just-
Oh, yeah, yes, sure, yeah. I was wondering if in your model you included all of the pollution from the production phase, from the installation phase, where they're digging a hole, and also during the operation phase, you include the, CO2 produced by a backup generator, backup coal and gas. And then in the deconstruction phase, did you include the amount of greenhouse gas involved in taking the curtains down, digging the concrete up and hauling the blades off? So those are 4 phases, and you're only dealing with 1, I think. So I want to include those other phases because the CO2 is there.
What's the question?
Okay, so.
That's it.
I think that the witness answered that when he was answering Ms. Grice's question. And do you want to just give us an answer about what was included in this study and what was, and to the extent it's limited, which you already explained?
Sure, Your Honor. So yes, full life cycle analysis would include the municipal production that you were discussing. In the larger zero carbon plan, that is electrification of all industrial processes. So that includes transportation and agriculture. There's where there are needs for combustion of gases, there are clean gases that will be needed in the future as well. So all those modes of production will be either electrified or between clean gases in the future.
But you said the total, whatever it was, you did not include those in it. You did not do a total, is that right?
He said that,
Yes, that's fine. Thank you very much.
Any regret?
Okay,
Do you have Ross? Oh,
just one question. You did not analyze, good afternoon, sir. Good afternoon, sir. My name is Eric Olson. I'm here with Wisconsin Property Monitor LLC. Can I ask you just one question, sir? You did not calculate or analyze what effect, if any, the Badger Hollow Wind project would have on the reliability of the grid. Is that true?
I did not provide any reliability assessments.
Okay, thank you.
All right. Ross? Go ahead.
Hi, Mr. Cal, Larry Reagan. Does your model include for example, 6.5 megawatt turbine, the loss of efficiency over a decade, over 2 decades, to the end of its life? Is that analyzed in the model?
I think you might be referring to the zero carbon study that gets to zero carbon by 2050.
Yes.
Correct? Yes, so generally all forms of energy will be at a D rating as the years progress, including wind turbines and solar and other generation resources, and that does incorporate losses and intervention.
What would you estimate after 10 years the efficiency of a 6.5 megawatt,
I'm sorry, 6.5?
6.5 megawatt turbine?
That's a good question. It might be in the application materials. Just from my industry knowledge, I think the general assumption is 1%. General assumption.
Thank you.
Right? Redirect. Do you have questions? Yeah. Go ahead.
All right, thank you, Mr. Kell. I think I only have one question here. When we're talking about the zero carbon transition study, did that study consider multiple scenarios?
Yes, it did.
And are those scenarios the only ways to reach zero carbon in the state of Wisconsin?
No, we don't.
Okay, and so in Wisconsin, does this study carry the weight of law?
No, of course it doesn't.
So these projects are designed in a piecemeal fashion and presented to the commission one by one.
That's the construction case CPCN process in the state of Wisconsin use?
So in order to reach zero carbon in Wisconsin, the commission has to take the projects that are presented and approved, and that's how we get to our resource mix.
Generally, yes, that's right.
Okay, and so the net zero study is just an attempt to model future needs, but those needs could be addressed in many different ways.
That's correct.
Okay, I don't think I have any other questions here.
All right, great. Your excuse, thanks very much. How many of these cases do you have to do? Let's go off the record. So I think we're done for our witnesses for today. What do you say about meeting back here at 9 AM tomorrow? Let's jump started a little bit. We won't have any motion to review, hopefully. So we can get right with the witnesses. So for the applicant, we have Howard Hankard, Elder.
Dr. Ellen Hogan.
Ellen Bogan, right? Sorry, Kurtz. And right, so that's, and we want to take Howard.
And Abner Patton.
I'm sorry, I can hear that.
We also have Abner Patton.
That's right. Okay, and Howard, we will take first, is that correct?
Yes, subject to me confirming that he can do 9 o'clock, which I will do right now.
Oh, okay, well, that's fine, well, we'll have plenty of time, just make sure, so that's the order so far, so everyone knows, and then we'll work on the interveners down the list, like I said before. Look at the operative evidence list, that's the order of the witnesses. I guess there's only one witness per party. That's simple, and then we'll take the rest of the commission staff. Anything else we needed to discuss before we break? No, all right. Thanks very much. We'll see you at 9 AM. Take care.